Come back to the chambers. Not necessarily say that, yeah. Yeah. Law firms? I don't think so. No. No, we got 45 left to do. Yeah, start, but quorum. 1, 2, 3.
But when I try to make sure that I don't do that, he forces me.
Proceedings are resumed. Please be seated.
As a puddle of mud.
Premier 45.
Mr. Chairman, just before we took the suspension, I had a little confusion because I've been following all of this very carefully, and I knew we had determined that we needed to make an amendment to clause 44, and I didn't see it. But it is there. It's just in the wrong order. So we should take the amendment to clause 44 before 45. It's 19 rather than 18. So if you could take that first and then go back to 18.
Clause 44, keeping name on roll.
Mr. Chairman, I move that the bill be amended in clause 44 as follows. A, by deleting subsection 1 and substituting the following subsection. 1, the section applies if an attorney at law who is not a Caymanian, A, is employed by a law firm or an affiliate of a law firm, or B, is an in-house counsel, does not wish to practice Cayman Islands law, but wishes to keep the attorney at law's name on the roll. And B, in subsection 4C, by inserting after the words disciplinary complaint or the words any other. Mr. Chairman, the point of this amendment is to ensure that where a Caymanian lawyer ceases to practice Cayman Islands law, their name would not be automatically removed from the roll. It would remain unless and until they wish it to be removed. Whereas in the case of a non-Caymanian lawyer, it will be removed if they cease to practice, and after having received a notice, has not done something to persuade the the clerk that they should remain after a 12-month notice. They actually have to apply to keep their name on for a non-Caymanian lawyer.
If no other member wish to speak, the question is that the amendment stand part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question is that clause 44 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 44 as amended stands part of the bill.
Clause 45, law form obligation to give notice.
Premier.
Mr. Chairman, I beg to move that the bill be amended in clause 45(7) by deleting the word 5 and substituting the word 10.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is now that clause 45 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 45 as amended stands part of the bill.
Clause 46, attorney at law may administer oaths. Clause 47, attorney at law and recognized law entity may sue for fees and costs.
Question is that clauses 46 and 47 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clauses 46 and 47 stands part of the bill.
Forgive me, Mr. Chair. I'm just trying to follow suit with the government's list of amendments to this bill. And if they can indicate what number of amendment they're under, because I was just looking under number 18, clause 45,
Yes.
and then
We'll pass that, but the one came before the next, actually. That's what happened.
agreed. But then in 19,
And it was explained.
what part was explained, Mr. Chair? I don't follow.
With the difference between 18 and 19. 19 came first, actually, 44 before 45.
Gotcha. Thank you, Mr. Chair.
I just a misprint.
Clause 48, attorney at law shall have a practicing certificate to practice.
Mr. Chairman, I beg to move that the bill be amended in clause 48(3)(b) by inserting after the word remains, the word within.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Mr. Chair.
Those against,
Mr. Chair, I do have a concern about this area of practicing certificates, and I just a way of advice as to where to address this concern about practicing certificates and the penalties for those who may find themselves foul of the law. Whether or not I can highlight my concern about where there's a lack of penalty for the associated firms with those persons who acquire the practicing certificates. If the government or the AG could indicate where would be the best place to have that concern highlighted, under which clause, rather than me going, but I just don't want to miss the opportunity because it's relevant to the practicing certificates outside of this jurisdiction.
Mr. Chairman, is the member seeking without notice to propose an amendment?
I don't think he said anything about an amendment. Honorable member, you didn't say anything about an amendment?
No, sir, but if the government is willing to accept one without notice, I'd be happy to present one.
No, I'm just wondering what is the purpose of the intervention, because we've had over 100 proposed amendments. So why isn't this one?
Well, Mr. Chair, through you, I appreciate the Premier's acknowledgement of lack of amendment being proposed, but as we all recognize by the number of amendments by the government, by the number of amendments by the opposition and the independent members, that this law is not perfect. And therefore, as we go along, we may find things that are concerning, and maybe the government may be
but the time
willing.
for that is past.
Mr.
Honorable
Chairman,
member, are you questioning, what are you questioning here?
but I'm trying to answer the Premier's statement.
No, but
So,
Mr.
Premier-
Mr.
The
Chair,
chair is speaking to
how-
you now,
Yes, sir.
not the premier, the
Okay.
chair. What are you trying to seek in your
Right.
question here?
My question is, there may be a potential suggestion for an amendment, and we've had discussions with the Honorable Premier and the Attorney General about those concerns. And with their knowledge of that concern, where would be the best place to have that discussion for a potential proposal for an amendment?
Mr. Chairman, there is a reason why there are rules about notice for amendments, because otherwise, everything that pops into a member's head in this House, in this committee, will wind up being the subject of another massive debate. We have had, as I said, over 100 proposed amendments here. The government's amendments are the result of discussions with the opposition, with the broader public, with attorneys at law, and we've even accepted some from the member. But, Mr. Chairman, it is your decision, obviously not mine, but I think we'd be going down a really dangerous and long and arduous road to now say that members are free to propose any amendment that they want at this stage.
Mr. Chairman, if I may add, I do appreciate the proper process for this committee. But Mr. Chairman, I must say that I've gotten an extensive list of the government's proposal just today. So I haven't had the opportunity to digest them myself. And I think it's fair to understand that I've tried my endeavor best to have off-air conversations, so there won't be much discussion. So the government is aware of what I'm trying to address. So it shouldn't be, obviously, if you allow, Mr. Chairman, something that cannot be easily and quickly addressed.
Well, Mr. Chairman, we have indicated, we had a 3-hour meeting. We've indicated, AG and I, again have indicated to the member, we are not prepared to accept his proposed amendment. So we're just spending time here so that he can air his view.
Mr. Chairman, I'm not speaking about the opposition's amendments.
The Honorable member, as you perhaps have heard, the government is moving on their program. They're not minded to accept amendments at this point in the discussion in committee.
Mr. Chairman, I heard you say that. I did not hear the Honorable Premier say that. Now, if the Honorable Premier is not willing to consider amendments in a bill that is not 100%, then he could be happy to say so.
Mr. Chairman, no bill is perfect. This bill has more proposed amendments with than any bill I've known.
And one more shouldn't kill it.
And Mr. Chairman, there is a process. The member has had this, and he's been in consultation with his lawyer folk. He's had this for more than a month.
Well, I'm glad that you've told this honorable committee that I've been in consultation. You see that I'm doing my homework, but I didn't get the consultation of your amendments until this morning, Mr. Premier.
But this is not one of my amendments. This
No,
is one
I
of
agreed.
yours.
I agreed.
Yeah.
But if we're going to talk about process, if we're going to talk about the ability to do my job, I can't do a job and talk to my legal friends that he's talking about.
Mr. Chairman,
today.
Can we suspend so the member can prepare a proper amendment and bring it back to the committee, and we can decide whether we accept it or not?
Fine, that sounds good.
So that's fine, Mr. Chairman.
Up until now, though, this chair hasn't heard and understood what it is that the member is seeking.
I am happy to stay here as long as it takes,
No,
sir.
So am I.
no,
We'll adjourn at 7:30 and come back tomorrow.
Honorable members, I am not going to allow that because we got plenty to do. And if the member seeks an amendment, I hear what it is, then go and draft that amendment and then we'll come back to it. We can come back, we can do that.
No, I'm okay with that, sir.
Well, but you need to go ahead, because up until now, I haven't seen anything. I still don't know what it's all about. I know that you had some discussion, but I don't know what it's all about. Or I heard you saying you had some discussion.
Thank you, Mr. Chair. So are we accepting a short break for me to get the amendment
No,
done?
we're not, no. We're gonna continue, and then you can go and get your amendment, and then come back. And
So,
we'll
Mr. Chair,
come back to that point.
am I supposed to miss the opportunity to do people's work when these amendments are being discussed? Based
You
on that?
know, honorable member, I can't do nothing about that.
So
I'm
I should-
giving you an opportunity to draft an amendment, bring back and let the chair see it, and then we take it from there. In the meantime, business of this committee has to continue.
Mr. Speaker, Mr. Chair, I can't afford to miss out the opportunity to make sure I examine all the amendments. So therefore, the position you left me with is that I can't do the amendment, because you're asking me to not be in the chair for the other amendments that I
Honorable
may have
member,
concern about.
I keep hearing you say, you left me. I don't need to reiterate some things that's already been said in this committee.
Which is,
Right? Listen, I am not going to sit here and have this kind of conversation, because I am not involved in these meetings. I don't know what you all do. Okay? I am the chair. If you are going to bring an amendment, bring it, and I'll consider it. If you know what it's all about.
Mr.
If
Chairman.
if you need legal advice to get it, then perhaps you ask the Attorney General to help you with it. That's what I would do.
Mr. Chairman, there's no need to speak to me like that. No need whatsoever.
Listen,
Now,
we're moving on, okay? Because I'm not a child. I'm moving on.
Well, move on. Nobody's stopping you from moving on, but you don't have to talk to me like that.
I have to, because you're not listening. When I was talking softly, you're not listening, and you keep
No, there's a
you keep
difference between not
goading. You
listening
think I
and
don't know when I'm
agreeing.
goaded? Don't you do it. Please continue. One more time, I'm giving you an opportunity to draft an amendment, seek the Attorney General's permission or assistance, and get it to the committee, because I'll come back to it. If you're not going to do it, then I'm going to take the vote on it.
Mr. Chair, unless there's a time for me to pause and get that done, then it makes no sense, because I don't want to miss the other proceedings of the House. So you can move on, Mr. Chair.
Question is that the amendment stands part of the bill. All those in favor? All those in
Mr.
favor?
Chairman, I don't
please
think we
say
even remember which amendment it is now, sir.
48.
48-3. Mr. Chairman, if you put the question again, please.
Question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Amendment stands part of the clause. Question now is that clause 48 do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 48 as amended stands part of the bill.
Clause 49, application for practicing certificate.
Mr. Chairman, I move that Section 49 be amended. A in subsection 2, by inserting after the words law firm, the words an in-house counsel or a statutory authority, and B in subsection 3C, by inserting after the words disciplinary complaint or the words any other.
Amendment has been moved. Is the Premier speaking to the amendment?
No, thank you, Mr. Speaker. It's just to ensure that we cover those entities in the definition.
Question. If no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause 49 49? 49 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 49 as amended stands part of the bill.
Clause 50, issue of practicing certificate.
Honorable Premier.
Thank you, Mrs. Chairman. Mr. Chairman, I move that the bill be amended in Clause 54B by inserting after the words disciplinary complaint or the words any other.
Premier, are you speaking there too? The amendment has been moved.
No, thank you, Mr. Speaker.
Question is that clause 54. The first question is that amendment stands part of the bill. All those in favor, please, stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question is that clause 50, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 50 as amended stands part of the bill.
Clause 51, when a practicing certificate becomes void.
Mr. Chairman, I
Premier.
move that the bill be amended in Clause 51 by deleting paragraph D and substituting the following paragraph. D. When an attorney at law, other than a Caymanian or a holder of a residence and employment rights certificate, ceases to be 1. Employed by a law firm or an affiliate of a law firm, or 2. An in-house counsel.
If no other member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 51, as amended, stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 51 as amended stands part of the bill.
Clause 52, details of practicing certificates to be published.
Question is that clause 52 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 52 stands part of the bill.
Clause 53, applications for recognition.
Mr. Chairman,
Premier.
I move that the bill be amended in Clause 53(1) by inserting after the word company the words partnership.
If no other member wishes to speak, question is that clause 53 stands part. The question is that amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 53 stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 53 as amended stands part of the bill.
Clause 54, recognition by board.
Mr. Chairman, I move that the bill be amended by deleting Clause 54 and substituting therefore the following clause. Recognition by council. 54(1). The council may, subject to subsection 2, recognize a company, partnership, or limited liability partnership as a recognized law entity if the council A is satisfied that the company, partnership, or limited liability partnership complies with section 28(2)(c), and B, subject to subsection 2, is otherwise satisfied that the company, partnership, or limited liability partnership is a suitable body to practice Cayman Islands law. 2, the council shall have regard to such matters as may be prescribed in determining whether to recognize a company, partnership, or limited liability partnership as a recognized law entity.
No other member wishes to speak. Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question is now that the clause 54, clause 54 as amended, stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 54 as amended stands part of the bill.
Clause 55, Board to issue certificate of recognition.
Premier,
Mr. Chairman, I move that the bill be amended by deleting clause 56 and substituting the following clause.
55.
Oh, I'm getting ahead of myself. Sorry, Mr. Chairman, I'll start again.
Continue, please.
That the bill be amended in clause 55 by inserting after the word company, wherever it appears in subsections 1 and 3, the word partnership.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is now that clause 55 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 55 as amended stands part of the bill.
Clause 56, appeal against refusal.
Refusal.
Appeal against refusal of recognition.
Premier.
Mr. Chairman, I move that the bill be amended by deleting clause 56 and substituting the following clause. Appeal against refusal of recognition. If the council refuses to recognize a company, partnership, or limited liability partnership as a recognized law entity, the company, partnership, or limited liability partnership may, with leave of the Court of Appeal, appeal to the Court of Appeal against the refusal on the grounds that the refusal was unreasonable, having regard to all the circumstances.
If no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 56 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 56 as amended stand part of the bill.
Clause 57, changes to be notified. Clause 58, recognized law entity may only practice Cayman Islands law. Clause 59, name of a recognized law entity.
Question is that clauses 57, 58, and 59 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 57, 58, and 59 is now part of the bill.
Clause 60, recognized law entity wound up.
The Premier,
Mr. Chairman, I move that the bill be amended by deleting clause 60 and substituting the following clause. A recognized law entity ceases to be a recognized law entity if a winding up order or its equivalent under the Companies Act 2020 revision, Limited Liability Companies Act 2020 revision, Partnership Act 2013 revision, or the Limited Liability Partnership Act 2017 is made in respect of it.
if no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. Clause, the question now is that clauses 60 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 60 as amended stands part of the bill.
Clause 61, companies ceasing to be a recognized law entity and continuing to practice.
Mr. Chairman,
Premier,
I move that the bill be amended in clause 61 as follows. A, in subsection 1, Roman numeral 1, by inserting after the word company, wherever it appears, the words partnership. And Roman numeral 2, by inserting after the word director, the words partner. And B, in subsection 2, by inserting after the word company, wherever it appears, the word partnership.
question is, if no other member wishes to speak, that is, that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 61 as amended stands part of the bill. All those in favor? Those against, the ayes have it. Clause 61 as amended stands part of the bill.
Clause 62, falsely claiming to be a recognized law entity.
Question is that clause 62 do now stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 52 stands part of the bill. Is it 62? Clause 62 stands part of the bill. Clause 62.
Clause 63, practice of Cayman Islands law by attorney at law in another jurisdiction.
Premier,
Mr. Chairman, I move that the bill be amended in clause 63(1) by inserting after the words an attorney at law, the words
3.
other than a Caymanian.
Question is that that the amendment do stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question is now that the clause 63 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 63 as amended stands part of the bill.
Clause 64, annual operational license.
Mr. Chairman, I move that the bill be amended in clause 64 as follows. A, in subsection 2, by deleting the words clerk of the court wherever they appear and substituting the word counsel. B, in subsection 4, by deleting the words clerk of the court and substituting the word counsel. C, in subsection 5, by deleting the word and substituting the words subject to subsection 6 and, comma, or semicolon. And D, by inserting after subsection 5 the following subsection as 6. The council may suspend or revoke an annual operational license where a law firm breaches a provision of this law or regulations made under this law. And E, by renumbering subsection 6 as subsection 7, and in renumbered subsection 7, by deleting the words clerk of the court and substituting the word counsel.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 64 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 64 as amended stands part of the bill.
Clause 65, insurance.
Premier.
Mr. Chairman, are we satisfied that this committee is co-rate? All those things we were voting on? Yeah, but I still didn't make it co-rate.
But I'm not sure how how the leader of opposition could say, because
They
he was
can't,
outside.
Honorable Member, if you're calling for quorum, at this point, that can be accepted. But beyond that, or behind that, we already passed that. And I thought we've had enough members in at that time.
That's why I'm asking you, Mr. Chairman, if you're satisfied that the committee was co-rate during all those decisions.
You mean during your absence?
Yeah.
Yes, I was absent, but the committee still wasn't co-rate. Was it?
How would you know that?
It's not
Well,
a
when
question.
I walk in was only 7 people.
Honorable Member, at this point in time, you can't question it, you know that.
Yeah.
You can question that we are at this point not quoted,
Mr.
but you
Chairman,
can't question that we weren't quoted before.
when I walked in, there was only 8 people.
When you were walking in, there were people walking out, as you might have noticed.
So can we ask the member from Georgetown since he was here?
Honorable Member, far as I am concerned as presiding officer, we were quoted. If you are seeking a quorum at this point, then raise that. But you cannot raise something that you were not at and then ask a member to verify it. That, you know better than that. You've
No,
been here
I
too
can't
long.
ask him to verify it, but you can ask him if he were.
I
But you
don't-
say as far as you're concerned,
I
you
don't
were
need to ask
co-rate.
him. I was sitting in this chair. I'm saying we were quoted. And if you all do have anything else to rub it, just leave the chair alone so that we can get on with the business.
Go back outside and smoke some more cigarettes.
That's not your business.
You're supposed to be in here doing the country's business. coming
Yeah,
in and
but
trying
you're
to
supposed to have
disrupt.
quorum too.
Yeah, because you're supposed to make it up.
Yeah, like you not got a majority.
You all get paid. You're supposed to be in here doing your work.
Oh, you starting that McKeewa thing now?
Please, as you say, don't wall me in this.
Speaking of work, okay, working now. Mr. Chairman, in all honesty, I'm a new member. But
Unless you have a point pertaining to where we're at this point in time, if you're talking about quorums, you're not going back there, okay?
so you want
If you were here,
Well, you just
remember,
let- you just
as
let the
long as
Premier
you've been in
talk
this
about
house,
some-
you would have known that we were quoted
But
or
they
not
know
quoted because you not came here yesterday. You've been here 4 years now.
Mr. Chairman,
And so, as far as the chair is concerned, we were quoted. From what I saw, when the leader of the opposition was walking in, some members were walking out. As far as I'm concerned, that's what I saw.
Mr. Chairman, what you all mean this for? You don't even know what you're about to say, but you're talking already? Mr.
Well, I
Chairman,
can tell you this,
Mr.
you already had your chance. That's it. Please, let's get back to the agenda. Unless somebody's calling for a quorum. If nobody's calling for a quorum, as far as I'm concerned, we have 2, 4, 6, 7, 8, 3 is 11 members. I wish I could. Remember 65? Premier, you didn't. The Premier, please. Order in this committee.
Mr. Chairman, I move that the bill be amended in clause 65 by deleting the word may and substituting the word shall.
Question is, unless members are prepared to speak, Question. Question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 65 as amended stands part of the bill. All those in favor, please say aye. Aye. Those against? The ayes have it. Clause 65 as amended stands part of the bill.
Clause 66, annual compliance certificate.
Mr. Chairman, I move that the bill be amended in clause 66.5 by deleting the word 5 and substituting the word 20.
Question is, unless anyone prepared to speak,
Mr. Chair,
the member for Georgetown Central.
Mr. Chair, forgive me again for my lack of process understanding. I sent an amendment on this bill. Does the government get their chance to submit their amendments even though those amendments are 7 days after mine first? Is that how it works?
Before you get to that, the question is that the amendment as moved by the Premier stands part of the clause. All those in favor?
Mr. Chairman, I have something to say about the clause because I also have amendment to the same exact clause.
Yeah, but
Yeah. Yeah. I have courage of the bill.
Mr. Chairman, I would like to speak to the bill. Speak to the amendment.
the amendment is
But,
open.
but Mr. Chairman,
He has not taken the vote
Yeah.
yet. So I'm allowed
He
to
hasn't
speak to your
spoken to it.
amendment.
no, but Mr. Chairman, I haven't got to speak to it either.
Yes,
It's my amendment.
it is your amendment, Premier.
So,
Premier,
I know the member's desperate to get over the side, but he got to take his time. I hope I'm long retired by then. Mr. Chairman, this amendment to clause 66.5
66.
increases the penalty for a firm that fails to comply with the requirement of this section from $5,000 to $20,000, so that the amended subsection will read: if a law firm fails to comply with a requirement of this section, each manager of the law firm commits an offense and is liable on summary conviction to a fine of $20,000. So that is the effect, Mr. Chairman, of the amendment.
Honorable members, the member for Georgetown Central.
Thank you, Mr. Chairman. I'm a bit confused, Mr. Chairman, because in the meeting this morning, we discussed this particular section, the clause, and the government gave me their commitment to accept my amendment that was filed before theirs. And what I see happening now is as if the Premier is trying to suggest that this was their amendment when mine was filed from 7 days before theirs, and don't even have the decency to even say, well, boy, we had a discussion and we agree with the member to increase it to 25. I mean, is that the normal thing, or what we're doing here?
Asking the chair to do what?
Well, I'm asking the chair if the government has changed their position. What's the point of having negotiations and discussions about these amendments and talk about how much we went through this morning if we're not going to agree to what we said?
Premier,
Mr. Chairman, the member is quite free to move his amendment in due course. What we have certainly not had the entire evening is the cooperation of that member with respect to anything else that we're trying to do. So I don't know where he's coming from about this, this wonderful partnership that we have with him with respect to this bill, because we are certainly not feeling the love out here.
the question is that the amendment stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 66, as amended, stands part of the bill. You're going to still move yours?
Of course, I'm going to still move mine, Mr. Chair. You're not going to give me my privilege of this committee?
Is it the same thing? No. Let's see. This is the same, your amendment is the same as what the government has moved.
Mr. Chair, if you read the amendment appropriately and clearly, one says to exchange a word, the other one is to put a word before another. So they're not the same amendment.
Honorable Member for Georgetown Central, continue.
Yes, sir. Thank you, Mr. Chair. In accordance with the provisions in the Standing Order 52.1 and 2, I, MP Kenneth Bryan, elected member for Georgetown Central, give notice to move the following amendment to the Legal Services Bill 2020. That the bill be amended as follows in Clause 66, the annual compliance certificate, in Clause 66.5 to insert in the last line after the word of the word 20, and therefore the bill would read,
The member may speak to his amendment if you care to.
thank you, Mr. Chair. The bill will then read under under Clause 63, 2, an attorney at law who contravenes subsection 1 commits an offense and is liable to a summary conviction to a fine of, forgive me, Mr. Chair, I'm reading the wrong section here. Annual compliance, section 66, 5. If a law firm fails to comply with the requirements of this section, each manager of the law firm commits an offense and is liable to a summary conviction to a fine of $25,000, which the government agreed to just hours ago.
The question is that the amendment as put forward by the member for Georgetown Central stand part of the clause. All those in favor, please say aye. The member for Georgetown Central, it's your bill, or your motion, or your amendment.
But Mr. Chairman, what's the point of
Chairman, you
voting on
just
it
put
when
it
the
to the
members know they're not going to support it after they make
I'll
arrangements
repeat the
behind?
question then. The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against?
No.
The noes have it. The amendment fails. Question now is that the amendment, that the clause 66 as amended stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 66 as amended stands part of the bill.
Clause 67, recognize legal educators. Clause 68, system of legal education and practice legal training, practical legal training. Clause 69, regulations in respect of qualifying as an attorney at law. Clause 70, regulations for program of legal education or practical legal training. Clause 71, regulations, service under articles of clerkship. Clause 72, qualifications required to take on an article clerk. Clause 73, recognized law entity may take on an article clerk. Clause 74, articles of clerkship served in government offices. Clause 75, service in a legal or judicial department. Clause 76, power of the board to discharge articles of clerkship. Clause 77, transfer of articles of clerkship. Clause 78, obligations of attorney at law or recognized law entity in relation to an article clerk.
Question is that clauses 71 through, clauses 67 through to 78. Clauses 67 to 78 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? Ayes have it. Clauses 67 to 78 stands part of the bill.
Part 11, investigation of alleged professional misconduct.
That's an amendment. You have an amendment? Or?
That's not a subject to an amendment. The next amendment I have is 81, clause 81.
No, 34, section number 34.
Oh, sorry. Yeah. Sorry, Mr. Chairman. Mr. Chairman, I move that the bill be amended in Part 11 in the part heading by inserting after the word investigation the words and determination.
Let's do the same way. Yeah. Is that the amendment as regards to part 11 do stand part of the bill. It's so to make it absolutely clear, the question is that the amendments stand part of the part 11. That's a funny way of wording it, but that's going to be very clear so the AG will understand when he go to, and this is what I don't understand either, but do his work on it. I know he can do that.
Yeah.
Because it's, just to say, it's not, from my understanding, it's not a complete clause. It's the heading. It's the heading, part 11. So we got it clear. It's part 11.
Correct.
All those in favor, please say aye.
Aye.
Those against? The ayes have it. Part 11, heading as amended, stands part of the bill.
Clause 79, application to senior office holders. Clause 80, complaints of professional misconduct by attorney at law.
Mr. Chairman, I move that the bill be amended by deleting clause
No,
8.
no. 79 and 80. Question is that clauses 79 and 80 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clauses 79 and 80 now stands part of the bill.
Clause 81, board to investigate complaints.
Mr. Chairman, I move that the bill be amended by deleting clause 81 and substituting the following clause. Legal Services Disciplinary Tribunal. 81.1. There is established a body called Legal Services Disciplinary Tribunal for the purpose of hearing and determining matters referred to it under this law in respect of alleged professional misconduct by attorneys at law. 2. The disciplinary tribunal consists of the following members appointed by the council. A retired judge who shall be the chairperson of the disciplinary tribunal, and B, subject to subsection 3, a panel of 7 members appointed on an annual basis who shall be attorneys at law of at least 10 years standing. 3. Where the council refers a matter to the disciplinary tribunal under section 82.12, the chairperson of the disciplinary tribunal shall appoint 2 members of the panel referred to in subsection 2B, whom the chairperson considers suitable to comprise the disciplinary tribunal for the purpose of hearing and determining the matter. In the exercise of its functions, the disciplinary tribunal shall not be subject to the direction or control of the council or any other person. 5. Subject to this act and the regulations made under subsection 8, the disciplinary tribunal shall regulate its own procedures and may make rules governing its procedures. 6. The disciplinary tribunal shall publish both in the Gazette and in such other media as the disciplinary tribunal determines notice of any rules made by the disciplinary tribunal under this section. 7. The notice under subsection 6 shall state where copies of the rules made by the disciplinary tribunal under this section may be obtained. 8. The Cabinet, after consultation with the Council, may make regulations with regard to the conduct of proceedings by the disciplinary tribunal and any other matters relating to the disciplinary tribunal that the Cabinet may consider necessary. 9. A person shall not participate as a member of the disciplinary tribunal and of the Council in relation to the same matter. 10. A member of the disciplinary tribunal is not liable for claims, damages, costs, charges, or expenses resulting from the discharge or purported discharge of a function of the member as a member of the disciplinary tribunal. 11. Subsection 10 does not apply to claims, damages, costs, charges, or expenses that are caused by the bad faith of the member of the disciplinary tribunal. Mr. Chairman, that is a whole new section inserted after or as a result of the consultation process in which we concluded and agreed that it is only proper that there be a separate and freestanding disciplinary tribunal to actually adjudicate on complaints of breach of discipline, as those complaints would have been investigated by the council itself. So we didn't want a situation where the council was investigating the complaints and then essentially prosecuting them and determining whether or not they were made out. So, as I've said before, this bill has had extensive consultation, broad-based consultation, hence the many committee stage amendments being brought by myself on behalf of the government.
Does any other member wish to speak? If not, question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against? The ayes have it. The amendment stands part of the clause. The question is now that clause 81 as amended stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 81 as amended stands part of the bill.
Clause 82, Board to publish rules.
Honorable Premier.
Mr. Chairman, I move that the bill be amended by deleting Clause 82 and substituting therefore the following clause. Council to investigate complaints. 82.1. The Council shall investigate a complaint filed under Section 80. 2. The Council shall, on its own initiative, investigate any conduct of an attorney at law if the Council becomes aware that the conduct may constitute professional misconduct by the attorney at law. 3. The Council has no power to investigate any conduct by an attorney at law that was known or could reasonably have been known by the complainant or Council more than 6 years before the complaint was made or the Council became aware of the conduct. 4. The Council has the power to do everything reasonably necessary to investigate any conduct of an attorney at law that is alleged to constitute professional misconduct. 5. Without prejudice to the generality of the power of the Council under subsection 4, the Council may require the production of a document or any other information from a person who the Council has reasonable grounds to believe can assist in investigating the conduct. 6. A person commits an offense if the person, when required to do so under subsection 5, fails or refuses to produce a document or any other information or produces a document or information that is false or misleading. 7. A person who commits an offense under subsection 6 is liable A. On summary conviction to a fine of $20,000 or to imprisonment for a term of 2 years or both, or B. On conviction on indictment to a fine of $50,000 or to imprisonment for a term of 5 years or to both. 8. The Council shall make rules regarding the procedure for its investigation of the conduct of attorneys at law. 9. The rules made under subsection 8 shall set out A. The manner in which a complaint may be made to the Council about the conduct of an attorney at law, and B. The manner in which the Council will conduct this investigation into the conduct of an attorney at law. 10. The Council shall publish both in the Gazette and in such other media as the Council determines notice of any rules made by the Council under this section. 11. The notice under subsection 10 shall state where copies of the rules made by the Council under this section may be obtained. 12. Unless the Council, having investigated a complaint filed under Section 80 or the conduct of an attorney at law on its own initiative under subsection 2, finds that the matter is frivolous or vexatious, the Council shall refer the matter to the disciplinary tribunal.
If no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against? The ayes have it. The amendment stands part of the clause. Question is that clause 82 as amended stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause 82 as amended stands part of the bill.
Clause 83, powers of the board to investigate.
Honorable the Premier.
Thank you, Mr. Chair. Mr. Chair, I move that the bill be amended by deleting Clause 83 and substituting the following clause. Disciplinary tribunal to hear and determine matter. 83.1. The disciplinary tribunal shall hear and determine a matter referred to it under Section 82.12. 2. The disciplinary tribunal has the power to do everything reasonably necessary to hear and determine a matter referred to it under Section 82.12. 3. Without prejudice to the generality of the power of the disciplinary tribunal under subsection 2, the disciplinary tribunal may do any of the following: A. Convene a hearing to investigate the conduct. B. Issue a summons to compel the attendance of a person at a hearing. C. Require the production of a document or any other information from a person who the disciplinary tribunal has reasonable grounds to believe can assist in investigating the conduct. D. Require a person to verify by affidavit a document submitted or information provided to the disciplinary tribunal. And E. Examine witnesses on oath, affirmation, or otherwise at a hearing. 4. A person commits an offense if the person A. fails to comply with a summons issued by the disciplinary tribunal under subsection 3B. B. When required to do so under subsection 3C, fails or refuses to produce a document or any other information, or produces a document or information that is false or misleading. C. When required to do so under subsection 3D, fails or refuses to verify a document submitted or information provided to the disciplinary tribunal by affidavit when required to do so by the disciplinary tribunal. Or D. As a witness at a hearing by the disciplinary tribunal, fails or refuses to answer a question put to the person or provides an answer that is false or misleading. 5. A person who commits an offense under subsection 4 is liable: A. On summary conviction to a fine of $20,000 or to imprisonment for a term of 2 years or to both. Or B. On conviction on indictment to a fine of $50,000 or to imprisonment for a term of 5 years or to both. 6. Subject to this law and to regulations made under section 81.8, the disciplinary tribunal shall make rules regarding the procedure for hearing and determining a matter referred to it under section 82.12. 7. The rules made under subsection 6 may provide for preliminary proceedings to be held to determine if sufficient evidence of an attorney at law's conduct exists to show if it may amount to professional misconduct. B. Shall give an attorney at law whose conduct is in question a reasonable opportunity to be heard either in person or through counsel. And C. Shall provide that a hearing of the disciplinary tribunal is to be held in public unless the disciplinary tribunal is of the view that publicity would prejudice the interest of justice or commercial confidence. 8. The disciplinary tribunal shall publish both in the Gazette and in such other media as the disciplinary tribunal determines notice of any rules made by the disciplinary tribunal under this section. 9. The notice under subsection 8 shall state where copies of the rules made by the disciplinary tribunal under this section may be obtained. That's it, Mr. Chairman, rather long.
If no other member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 83 as amended stands part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. Clause 83 as amended stands part of the bill.
Clause 84, disciplinary sanctions.
Premier.
Thank you, Mr. Chairman. Mr. Chairman, I move that the bill be amended in clause 84 as follows. A, in subsection 1 by deleting the words, if after investigating any conduct of an attorney at law, the board is satisfied the conduct constitutes professional misconduct by the attorney at law, the board may take one or more of the following actions. And substituting the words, if after hearing and determining a matter referred to the disciplinary tribunal, the disciplinary tribunal is satisfied the conduct constitutes professional misconduct by the attorney at law, the disciplinary tribunal may take one or more of the following actions. And B, in subsection 2, by deleting the word board wherever it appears and substituting the words disciplinary tribunal.
If no other member wishes to speak, question is that the amendments that's part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that the clause clause 84 as amended stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 84 as amended stands part of the bill.
Clause 85, striking
Premier.
off. Striking off and suspension from practice to be published.
Mr. Chairman, I beg to move that the bill be amended in Clause 85 by deleting the word board and substituting the words disciplinary tribunal.
Question is that the amendment stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 85 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 85 as amended stands part of the bill.
Clause 86, interim order.
Mr. Chairman, I move that the bill be amended in Clause 86 by deleting Clause 86 and substituting the following clause, therefore. Interim orders 86.1. If any conduct of an attorney at law is being investigated by the council, the court may make an interim order that the attorney at law be suspended from practice until the investigation has been completed and any subsequent order made by the disciplinary tribunal under Section 84 has come into effect. 2. If the investigation is into the alleged misuse of a trust fund by the attorney at law, the court, on the application of the council, may make an order that until the investigation has been completed and any subsequent order made by the disciplinary tribunal under Section 84 has come into effect, a trust fund operated by the attorney at law be operated by an accountant or a bank approved by the council.
Question is, if no other one member wishes to speak, that the amendment stand part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is that clause 86 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 86 as amended stands part of the bill.
Clause 87, restoration of name to roll.
Mr. Chairman, I move that the bill be amended in Clause 87.1 by deleting the word board where the first occurs and substituting the words disciplinary tribunal.
If no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 87 as amended stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 87 as amended stands part of the bill.
Clause 88, termination of suspension.
Mr. Chairman, I move that the bill be amended in Clause 88 by deleting subsection 1 and substituting the following subsection. 1. If an attorney at law has been suspended from practice on the order of the disciplinary tribunal under Section 84, the attorney at law may at any time apply to the council for the suspension to be terminated.
If no other member wishes to speak, question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. Question now is that clause 88 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause 88 as amended stands part of the bill.
Clause 89, form and proof of order of board.
Mr. Chairman, I move that the bill be amended in Clause 89 as follows. A, in the section heading by deleting the word board and substituting the words council or disciplinary tribunal. B, by renumbering Clause 89 as Clause 89-1. And C, by inserting after Clause 89-1 as renumbered the following subsection 2. A document purporting to be A, an order of the disciplinary tribunal, and be signed on its behalf by the chairperson of the disciplinary tribunal, shall, in the absence of evidence to the contrary, be taken to be an order of the disciplinary tribunal duly made, without proof of its making or proof of signature, or proof that the person signing the order was entitled to sign the order.
If no other member wishes to speak, the question is, the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question now is that clause 89 as amended stands part of the bill. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Clause 89 as amended stands part of the bill.
Clause 90, certain orders to be filed in court.
Mr. Chairman, I move that the bill be amended in Section 90 as follows. A, in subsection 1, by deleting the word board and substituting the words council or disciplinary tribunal. And B, in subsection 3, by deleting the words Section 94 and substituting the words Section 92.
Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is that clause number 90 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause number 90 as amended stands part of the bill.
Clause 91, enforcement of order of board.
Mr. Chairman, I move that the bill be amended in Clause 91 by deleting the word board wherever it appears, including in the section heading and substituting the words disciplinary tribunal.
Question is, if no other member wishes to speak, that the amendment stands part of the clause. All those in favor, please say aye. Those against, the ayes have it. The amendment stands part of the clause. The question is that clause number 91 as amended stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clause number 91 as amended stands part of the bill.
Clause 92, appeal from decision of the board.
Mr. Chairman, I move that the bill be amended by deleting Clause 92 and substituting therefore the following clause. Appeals 92.1. An attorney at law may appeal to the Court of Appeal against an action taken by the disciplinary tribunal under Section 84. 2. An appeal under subsection 1 shall be by way of a new hearing in respect of the conduct of the attorney at law that the disciplinary tribunal has determined constituted professional misconduct by the attorney at law. 3. A person aggrieved by a decision of the council may, with leave of the Court of Appeal, appeal to the Court of Appeal against the decision of the council. 4. An appeal under this section shall be made within such time and in such form as may be prescribed by the rules of the Court of Appeal. 5. On hearing an appeal under this section, the Court of Appeal may confirm, reverse, or modify the action taken by the council or disciplinary tribunal.
If no other member wishes to speak, the question is that the amendment stands part of the clause. All those in favor? Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause number 92 as amended stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause number 92 as amended stands part of the bill.
Clause 93, trusteeships held by attorney-at-law suspended or struck off. Clause 94, attorney-at-law shall comply with conditions or restrictions. Clause 95, board to inform police of possible offense.
Question is that clauses 93, 94, 95 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 94, 93, 94, and 95 stands part of the bill.
Clause 96, practice in the islands of the law of another jurisdiction.
Mr. Chairman, I move that the bill be amended in clause 9610 by deleting the words appeal to the court and substituting the words with leave of the Court of Appeal, appeal to the Court of Appeal.
Question is that the amendment do stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. The amendment stands part of the clause. Question now is that clause 96 as amended stands part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause number 96 as amended stands part of the bill.
Clause 97, false or misleading information.
Premier.
Thank you, Mr. Chair. Mr. Chair, I move that the bill be amended in clause 97(2) by deleting the word 10 and substituting the word 25.
If no other member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Those against? The ayes have it. The amendment stands part of the clause. The question now is that clause number 97 as amended stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clause number 97 as amended stands part of the bill.
Clause 98, liability of officers.
Question is the clause 98 stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clause number 98 stands part of the bill.
Clause 99, regulations.
Mr. Chairman.
Mr. Chairman,
I beg to move
Mr.
that.
Chairman, I would like to move a point of order.
Honourable member.
Thank you, Mr. Chairman. Under the standing orders 52.2, a notice of amendment or a new clause or a new schedule proposed to be moved to a bill should be given in writing no later than 2 days before or which that bill is to be considered in the committee. I do not accept this one under the standing orders because they didn't give me notice. The notice date on these are today, 16th day of December. Now, the provisions in this standing order protects all members of this House the opportunity to investigate the ramifications of all amendments proposed to this House. I have not been given that opportunity, so therefore I ask that you strike this amendment from the record.
Which amendment you asking to be struck?
The amendment proposed, the last amendment proposed by the government, 99.
That has not been moved yet. That's the one you're talking about?
Yes, Mr. Speaker, which is the one they are about to move now.
And why are you saying that?
Because the standing orders doesn't allow it to.
Which part of standing orders?
Mr. Chairman.
Section 52, 2.
I was
Section
going to say
50.
we're happy to do that, sir. We're happy not to move that, that's fine.
The presiding officer has the.
I know, I'm just indicating the government's position. We don't have any difficulty with this at all.
And so,
But Mr. Chairman, if that is the case, then they should be happy to strike off all of them because all of their amendments today were contrary to
No.
the standing orders.
Honorable member, the authority of the presiding officer is to waive notices at any given time.
Sorry?
The authority of the chair is that the chair can waive notices at any given time.
So, Mr. Chairman, if I understand what you're saying correctly, is that you've waived the government on probably one of the most important bills before this country, the opportunity to bring 50 amendments to the bill on the day of the amendments that's supposed to go to the committee, whereby Mr.
Yes, I did. In particular, that members have not raised it up until 10 minutes to 8. And you had them what? How long?
From this morning?
Okay.
So
Until this morning to 10 minutes to 8, no member of this honorable house raised any objection about the amendments that government put. Nobody raised about any yours. You came on the floor of the house and we took them at all the time.
Mr. Chairman.
I have waived, the presiding officer have waived the standing order, giving the government permission to put forward their amendments. That is done nearly every meeting of this honorable. That's not new.
I agree, Mr. Chairman.
And
but
an honorable member, you have had your say. We're moving on.
Mr. Chairman,
We are moving on. You have made you complete that complaint, and that's recorded in the Hansard.
Mr. Chairman, I beg to move the withdrawal of the proposed amendment to clause 99, which is in paragraph 49 of the notice of committee stage amendments.
Facts can come out now, though.
That's the point of objection. We withdraw it, Mr. Chairman.
The question is that amendment number 99,
The proposed amendment to clause 99.
the proposed amendment number 99 be withdrawn. That's the question, honorable members. All in favor?
Aye.
Those against? The ayes have it. The proposed amendment is withdrawn. And the member from Georgetown Central has an amendment.
Thank you, Mr. Chair. In accordance with the provisions of the Standing Order 52-1 and 2, I, MP Kenneth Bryan, the elected member for Georgetown Central, give notice to move the following amendments to the Legal Services Bill 2020. That the bill be amended as follows. In Clause 99, under regulations, to insert after the clauses 99.3 the following new subclauses 4, which reads as follows. No regulations shall be made pursuant to this law unless a draft thereof has been laid before the Parliament and a resolution approving the draft has been passed by the Parliament.
Amendment has been moved. Is the member speaking thereto?
Yes, Mr. Chair. And Mr. Chair, you saw that I just used the provisions within the standing order to ask you to revoke the previous proposed amendment by the government. One which I appreciated that the government was willing to do. But that previous provision is unlike this one, which those regulation that governs the regulations that govern the process upon which Cayman lawyers will be treated in the firms and their pathway to success within the industry of the legal fraternities in the Cayman Islands. Now, those regulations are the key piece of the puzzle to the protections that we all seek, or that has been the discussions in the airways and in this honorable house. And therefore, Mr. Speaker, because those regulations are so important, to have those regulations done behind the secret of cabinet and not in the public sunshine of this parliament, I think it's important that any regulations that are changed or proposed, because of the significance of those regulations and Caymanian lawyers in this fraternity, that any regulations have to come to this House to get a positive resolution, therefore the opportunity for debate in this honorable House. Now, the government was happy to withdraw the previous one, which only allowed a subject to debate. This one mandatory makes it a debate before the House, where the good people of this country, particularly those who are attorneys, can have the opportunity to see what the government's position our government position will be in respect to any regulations that has association with this bill. So I'd be interested to see if the government would rather have it done in secret behind cabinet than before the people, particularly because the regulations are so important to the success of young attorneys or all Caymanian attorneys and their pathway within the industry. So the government can indicate to their members what their position is.
Does any other member wish to speak? Does any other member wish to speak? The question is that the amendment to stand part of the clause. All those in favor, please say aye.
Aye.
Those against,
No.
the noes have it. The amendment has failed. Question is that
Mr. Chair,
us,
just a matter of clarity from a point of order. Are you given permission to waive the standing orders for all of their amendments that were proposed to this honorable House, the honorable committee?
that was done long time ago.
I don't recall that being on the record.
Honorable member, when a member submits a question or any matter to the presiding officer has a decision to make. If there's nothing wrong with it, it goes forward. If it needs suspension of standing orders, that is said. And in this case, where amendments come before the House in a day, in a couple of minutes, whatever, permission is usually given at that time, whenever that comes to my desk.
Fair enough, Mr. Chairman. I just trying to understand the provisions of 52.2, the importance of why they put the 2-day requirement in there. And that 2-day requirement is to give us enough opportunity to analyze it properly and make sure that we know exactly the ramifications of those changes. And you are waiving that opportunity for us to verify, correct?
The notice of any amendment, new clause or new schedule proposed to be moved to the bill shall be given in writing not later than 2 days before that on which the bill is to be considered in committee, and accept with leave of the chairman, no amendment of which notice has been given may be moved. Except with leave of the chairman.
Mr. Chairman, you're not incorrect. I agree. I read that part clearly, so I understand. But I want the honorable committee to recognize that exception leaves us, from a democratic perspective, at a disadvantage to examine those amendments and the ripple effects of them.
And most times those amendments, honorable member, are given a whole day, mostly. If it's a matter of a few hours, then members will bring that to the floor or to somebody's attention. Most amendments like that is given a day.
But we didn't give it a day. I got this at 11 o'clock today, Mr.
And it's
Chairman.
with the leave of the chair.
But that's what I'm saying. You didn't give notice that a leave was given.
I did what?
I was not given notice that the leave
Well, you're not the
was given.
chair.
Fair enough, fair enough.
But that one says, except with leave, nothing of the chair,
Yes.
nothing can be done.
Yes.
Belong me, and I talk about him, I talk about him.
No,
Listen.
they're not going to explain that.
They're the lawyers, not me. The first three words in it tells us what happens.
His?
Me
Yeah,
and
yeah,
you
yeah,
get
can-
permission.
Yes, we did. We rejected it.
Mr. Chairman,
Should have explained it to you, Kenneth.
This clause, no? So, no, I don't think we need to do anything with it.
Mr. Chairman, just a point of clarity. I'm not saying that you're supposed to notify anybody, but is there the assumption that the approval has already been given by the fact that you, the chair, and the clerk is reading it before the committee? Is that assumed that the permission has already been given? Otherwise, it wouldn't have gotten that far. Correct. Thank you, Mr. Chair. That's what I wanted to understand.
I don't know who can be back here the next election, after the next election. None of us might be. But if we are that blessed, we shall have a post-election seminar where some of these can be reinforced. Because I'm sure we've gone to enough seminars to know some of the standing orders and the provisions and conventions of Parliament.
Mr. Chairman, I agree with you, but it's not about knowing the standing orders. It's how they maneuver around the loopholes of those standing
And
orders.
if you
to
know,
play
then
their
they can't
games.
maneuver past you.
No,
But
no,
what you're raising now is not right.
No,
and
no,
we can
no.
stop right here now.
They can't do it without your assistance, Mr. Chair, because they couldn't get it passed without your approval.
No. You can listen. You go in a little bit too far, Mr. Member, and because you're new, I give leeway for all of that. But you have stated a lot of things that is in contravention of standing orders and what you say and how you say it to the presiding officer.
Sorry, Mr. Chairman. I apologize. I'm just talking about the
My mom used to say that when she used to beat the hell out of me too.
Yeah, but you can't beat me though. In that respect, that's okay. But I'm just saying that in respect to the standing orders, it says except with the leave of the chairman. So I am correct by saying they cannot do it without your approval. That's what I'm talking about in respect to the
I
standing
don't know
orders.
what you think you're going to get out of what you're doing, except that you got people listening that thinks that we are in a big quarrel, and I think that's what you aim to get at. But you are not playing with a little boy in this chair. I've been here 36 years. I know my standing orders. I know what I can and what I cannot do. And I don't need lawyers to tell me all the time. I get lawyers to reinforce what I believe and what I see and what I know. But you've gone a little bit too far, and you're doing it just to nettle me because I know how you do it. Please stop. And we've done. We have done. We have finished this point. Okay?
Clause 100, repeal and say.
I think we do it. Yes. And that is just this one. Okay. Honorable members, on 99, clause 99, I would appreciate us, for belt and braces' sake, taking that vote again. Question is that clause 99 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against?
We are voting on the clause in the bill.
In the bill.
Mr.
Yes.
Chairman,
Aye.
if they've taken the vote, you can't stop I'm sorry, forgive me, but they just voted, and then you're like stopping to try to correct them of what their vote was. They should know what their vote is.
You listen. You please understand, if you were asking a question, I would stop to try to answer it. If I wasn't sure, I would do just what I just did. And that's to ask to make sure that we have done the right thing by what we call belt and braces. That's taking the vote over, to make sure that we have taken the vote. No, you're wrong. I forgive you for your ignorance of the rules.
Clause 100, repeal and savings. Clause 101, savings, transitional and consequential provisions.
Question is that clause 100, the clauses 101, 100 and 101 stands part of the bill. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Clauses 100 and 101 stands part of the bill. Yeah. You have one to know.
Mr. Chairman, as the final matter, I beg to move that the bill be amended by deleting the word board wherever it appears and substituting therefore the word council.
That's just a general one.
Okay.
Dear Jesus. I can tell you, if certain other people were sitting in that chair, the sergeant would have let him out of here.
The question is that the bill be amended
Yeah,
by deleting the word board
and substitute the word.
and substituting the word council. All those in favor, please say aye. Those against? The ayes have it. The bill has been amended by deleting the word board and substituting the word council.
A bill for a law to repeal and replace the Legal Practitioners Law 2015 revision, to regulate the practice of Cayman Islands law, to provide for a system of legal education, to provide for a mechanism to deal with professional misconduct, and for incidental and connected purposes.
Question is that the title do now stand part of the bill. All those in favor, please say aye. Aye. Those against? The ayes have it. The title stands part of the bill. Question now is that the bill be reported to the House. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The bills will be reported to the Honorable House. Proceedings has resumed. Please be seated. Yes. You have a... Yes. The Premier will move the suspension of Standing Order 14 to 10-2, sorry.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10-2, that the business of the House may resume well after the hour of interruption.
Question is that the Honorable House do conduct its business after the hour of 4:30. All those in favor, please say aye. Those against? The ayes have it. The House business continues.
Report on bills. Legal Services Bill 2020.
The Honorable the Premier.
Mr. Speaker, I am to report that a bill shortly entitled the Legal Services Bill 2020 was considered by a committee of the whole House and after much contention passed with amendment.
The bill has been duly reported and is set down for a third reading.
Third readings, Legal Service Bill 2020.
The Honorable
Sorry.
Premier.
Mr. Speaker, I beg to move the third reading of a bill shortly entitled, the Legal Services Bill 2020.
Question is that a bill shortly entitled the Legal Services Bill 2020 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Legal Services Bill 2020 has been read
Can I have a
a
division,
third time
please?
and is passed.
I have a division.
Clerk, please divide.
Where is he?
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell. Aye. Honorable Juliana Connor-Connolly. Honorable Dwayne Seymour. Honorable Roy McTaggart. Aye. Honorable Joseph Hugh. Honorable Tara Rivers. Captain Eugene Ebanks. Ms. Honorable Barbara Connolly. Mr. David White. Mr. Austin Harris. Honorable Arden McLean.
Abstain.
Mr. Alva Saku. Mr. Kenneth Bryan.
Aye.
Mr. Anthony Eden. Mr. Christopher Saunders.
Abstain.
Mr. Ezra Miller. Mr. Barney Bush.
The results of the division: 10 ayes, 2 abstentions, 6 absentees. The bill has been passed.
Private Funding of Legal Services Bill 2020.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill short titled Private Funding of Legal Services Bill 2020 be given a third reading and pass.
The question is that a bill shortly entitled the Private Funding of Legal Services Bill 2020 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Private Funding of Legal Services Bill 2020 has been read a third time and is passed.
Virtual Asset Service Providers Amendment Bill 2020.
The Honorable the Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled Virtual Asset Service Providers Amendment Bill 2020 be read a third time and passed.
Question is that a bill shortly entitled the Virtual Asset Service Providers Amendment Bill 2020 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Virtual Asset Service Providers Amendment Bill 2020 has been read a third time and is passed.
Companies Amendment Number 3 Bill 2020.
The Honorable the Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Companies Amendment Number 3 Bill 2020 be read a third time and passed.
The question is that a bill shortly entitled the Companies Amendment Number 3 Bill 2020 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Companies Amendment Number 3 Bill 2020 has been read a third time and is passed.
Property Miscellaneous Provisions Amendment Bill 2020.
The Minister of Financial Services.
Mr. Speaker, I beg to move that a bill shortly entitled the Property Miscellaneous Provisions Amendment Bill 2020 be read a third time and passed.
Question is that a bill shortly entitled Property Miscellaneous Provision Amendment Bill 2020 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, the ayes have it. The Property Miscellaneous Provisions Amendment Bill 2020 has been read a third time and is passed.
Special Economic Zones Amendment Bill 2020.
The Honorable the Premier.
Mr. Speaker, I beg to move the third reading of a bill shortly entitled the Special Economic Zones Amendment Bill 2020.
Question is that a bill shortly entitled the Special Economic Zones Amendment Bill 2020 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Special Economic Zones Amendment Bill 2020 has been read a third time and is passed.
Penal Code Amendment Number 2 Bill 2020.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Penal Code Amendment Number 2 Bill 2020 be given a third reading and passed.
The question is that a bill shortly entitled the Penal Code Amendment Number 2 Bill 2020 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Penal Code Amendment Number 2 Bill 2020 has been read a third time and is passed.
Healthcare Decisions Amendment Bill 2020.
The Honorable the Minister of Health. Is it the Honorable the Attorney General?
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the Healthcare Decision Amendment Bill 2020 be given a third reading and passed.
Question is that a bill shortly entitled the Healthcare Decisions Amendment Bill 2020 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Healthcare Decisions Amendment Bill 2020 has been read a third time and is now passed.
Motions. Government Motion Number 1 of 2020-2021. Freedom of Information Law 2020 Revision. Freedom of Information General Amendment Regulations 2020. To be moved by the Honorable Attorney General.
The Honorable the Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move Government Motion Number 1 of 2020. Freedom of Information Law 2020. Freedom of Information General Amendment Regulations 2020. Mr. Speaker, the motion reads as follows. Whereas Can't manage without it. Thank you. Whereas Section 57 of the Freedom of Information Law 2020 revision provides that the Cabinet may, subject to an affirmative resolution of the Parliament, make regulations, A, generally for giving effect to the provisions and purpose of this law, B, prescribing the period of time for the doing of any act under this law, and C, for anything that is required or permitted to be prescribed under this law. And whereas the Freedom of Information Law 2020 revision, Freedom of Information General Amendment Regulations 2020 has now been laid on the table of this Honorable House. Be it resolved that the Freedom of Information Law 2020 revision, Freedom of Information General Amendment Regulation 2020 be affirmed by the Parliament pursuant to Section 57 of the Freedom of Information Law 2020 revision.
Question is, be it now therefore resolved that the Freedom of Information Law 2020 revision, Freedom of Information General Amendment Regulations 2020 be affirmed by the Parliament pursuant to Section 57 of the Freedom of Information Law 2020 revision. The Honorable AG.
I beg you. Thank you, Mr. Speaker. Mr. Speaker, this Parliament enacted the Freedom of Information Law 2007. Mr. Speaker, sorry, Mr. Speaker. So after this Parliament, sir, enacted the Freedom of Information Law 2007, the Freedom of Information General Regulations 2008 were, at that time, subsequently presented for affirmative resolution. The FOI law, Mr. Speaker, Freedom of Information Law, came into effect on the 5th of January 2009, and, Mr. Speaker, has fundamentally changed public sector operations. Mr. Speaker, the objects of the FOI law as set out in Section 4 are, and I quote, to reinforce and give further effect to certain fundamental principles underlying the system of the constitutional democracy, namely A, government accountability, B, transparency, and C, public participation in national decision-making. Mr. Speaker, by granting to the public a general right of access to records held by public authorities and subject to exemptions, which balance that right against the public interest in exempting from disclosure governmental, commercial, or personal information. Mr. Speaker, following amendments to the FOI law that were passed by this Parliament in November of 2018 and came into effect the following year, a working group was formed to consolidate and summarize proposals for subsequent amendments to the Freedom of Information General Regulations 2008. This working group, Mr. Speaker, included representation from the Office of the Ombudsman, the Legislative Drafting Department, and the Cabinet Office, which coordinates the administration of freedom of information across the entire public sector. Mr. Speaker, the current general regulations, first enacted nearly 13 years ago now, have been substantively impacted by amendments to the FOI law, particularly, Mr. Speaker, those which came into effect immediately following the coming into effect of the Data Protection Law 2017 on the 30th of September 2019. Therefore, Mr. Speaker, those regulations must now be amended in line with changes to the Primary Act. The regulations, Mr. Speaker, that honorable members are now being asked to affirm also provide for additional amendments that will improve operational efficiency of the FOI regime and strengthen the rights of both applicants for information and of third parties, Mr. Speaker, whose personal information may be requested under the FOI law. Mr. Speaker, the various provisions in these regulations can therefore be seen as falling into various categories when considering their purpose. These are: 1, refining, that is, Mr. Speaker, to align provisions to other relevant legislation. 2, clarifying, that is, Mr. Speaker, to ensure consistent and appropriate application across the entire public sector, which is made up of nearly 100 distinct ministries, portfolios, offices, statutory authorities, and government companies that all have the same obligations, must all fairly apply the FOI law and are together referred to as public authorities for the purposes of the FOI law, Mr. Speaker. Then, Mr. Speaker, there is modifying. That is, Mr. Speaker, to address a small number of what we have come to realize are overly burdensome procedural requirements that provide no real benefit to public authorities, applicants, third parties, or, Mr. Speaker, indeed the public. And of course, Mr. Speaker, then there is what we call necessary repeals, which is to remove regulations entirely if the authorizing provision has been repealed in the FOI law. In all of these instances where an authorizing provision was repealed in the FOI law, the relevant matter is now properly dealt with under, Mr. Speaker, the Data Protection Law 2017. Mr. Speaker, while these regulations include 16 amending provisions, very few will bring about substantive changes. Those changes that are likely to have an appreciable impact on FOI practice in the public sector are as follows, Mr. Speaker. First, written consultation in relation to the potential disclosure of third-party personal information will only be required if it is a living individual whose information has been requested. The exemption in Section 23 of the FOI law that allows government to not provide access to personal information if it would amount to an unreasonable disclosure continues to be available where it is necessary to protect information of either living or deceased individuals, Mr. Speaker. However, written consultation on the disclosure of such information is no longer required if the individual is deceased. Mr. Speaker, secondly, the relevant public authority will no longer be required to notify the Ombudsman if it decides to grant access to third-party personal information under the FOI law. The Ombudsman has indicated this notification is unnecessary, and it is also important to note that the Office of the Ombudsman will be directly informed by a third party if that individual decides to appeal the public authority's decision and disclosure. Mr. Speaker, thirdly, all internal reviews will be required to be logged in the tracking and monitoring system used by the government, which has been the practice since the FOI law first came into effect, but will now be legally mandated, Mr. Speaker. And finally, Mr. Speaker, on this point, the scope of the definition of personal information under the FOI law will provide further examples of the types of information that are included. This term will also be clarified in relation to public servants and contractors, making it clear, Mr. Speaker, that the general terms upon this and subject to which the individual would occupy a public service position that do not constitute personal information. While there may still be some legitimate public interest in personal information relating to public servants being disclosed under the FOI law, it is important for all parties to be clear that specific information such as educational history or work experience is still personal information, even if the individual is a public servant. The exemption for personal information is not absolute, Mr. Speaker, and provides for withholding information and records if their disclosure would amount to an unreasonable disclosure of personal information. Public servants, Mr. Speaker, must have the same rights as any other individual to be consulted in relation to disclosure of their personal information and to be able to make representations that will be considered in coming to a decision on access, Mr. Speaker. Mr. Speaker, these amending regulations were informed by, one, the review completed by the committee of this Honorable Parliament, two, practical experience and knowledge contributed by the Cabinet Office, which centrally coordinates FOI across the public sector, and three, Mr. Speaker, the views of the Office of the Ombudsman as a supervisory authority. Mr. Speaker, I would like to thank honorable members who participated in the initial review, for their recommendations, and also thank the public servants and the working group, Mr. Speaker, for their efforts in that initiative. Mr. Speaker, formation of these regulations will ensure the FOI regime continues to operate effectively across the public sector. It will also ensure the right of access to information is promoted and appropriately balanced against other rights and public interests where relevant. Mr. Speaker, the regulations themselves were approved by the Cabinet on the 24th of November 2020 and were previously laid on the table of this House. Mr. Speaker, I thank you and I commend the motion to honorable members.
Does any other member wish to speak? Does any other member wish to speak? Call on the Honorable AG to wind up.
Thank you, Mr. Speaker. Mr. Speaker, I wish to thank honorable members for their support of the motion as it relates to the regulations under the FOI law. Thank you.
Question is, be it therefore resolved that the immigration grant, a little bit ahead of myself there. Be it therefore resolved that the Freedom of Information Law 2020 revision, Freedom of Information General Amendment Regulation 2020 be affirmed by the Parliament pursuant to Section 57 of the Freedom of Information Law 2020 revision. All those in favor, please say aye.
Aye.
Those against, the ayes have it. Government motion number 1 is carried.
Government motion number 2.
The Honorable the Premier.
No, sorry, I haven't. Immigration Transition Law 2018, the Immigration Grant of Right to be Caymanian Order 2020, to be moved by the Honourable Minister of Employment, Border Control, Community Affairs, International Trade, Investment, Aviation, and Maritime Affairs.
Premier.
Yes, Mr. Speaker, that is the shortest title I have, I believe. Mr. Chairman, I beg to move government motion number 2 of the 2019-2020 session entitled The Immigration Grant of the Right to be Caymanian Order 2020 20. Whereas Section 26(1)(e) of the Immigration Transition Law 2018 provides that the Cabinet, acting upon the recommendation of the Cayman Status and Permanent Residency Board, may grant the right to be Caymanian in accordance with this section. And whereas Section 26(1)(e) provides that such grant shall be ratified by the Parliament, and whereas the immigration grant of the right to be Caymanian Order 2020 was laid on the table of the Parliament, be it therefore resolved that the immigration grant of the right to be Caymanian Order 2020 be affirmed by the Parliament pursuant to the provisions of Section 26(1)(e) of the Immigration Transition Law 2018.
Question is, be it therefore resolved that the immigration grant of the right to be Caymanian Order 2020 be affirmed by the Parliament pursuant to the provisions of Section 26(1)(c) of the Immigration Transition Law 2018. Honorable Premier.
Mr. Chairman, Mr. Speaker, this motion is brought in relation to the Cabinet grant of the right to be Caymanian to Mr. Kirk Williamson in accordance with Section 26(1)(e) of the Immigration Transition Law 2018. Mr. Speaker, in June 2017, an application was made to the Caymanian Status and Permanent Residency Board, and after a decision was taken to not recommend his application, Mr. Williamson appealed the decision through the Immigration Appeals Tribunal, which determined in July 2019 that he was indeed eligible to appeal and made the subsequent recommendation for the right to be Caymanian to the Cabinet. The application was approved by Cabinet at its most recent meeting, and Cabinet has requested that the decision be sent to the Parliament for ratification. I should correct that, Mr. Speaker. It wasn't the most recent meeting. It was the most recent meeting before the start of this meeting of Parliament. Mr. Speaker, I will now set out why the Immigration Appeals Tribunal and Cabinet are convinced that Mr. Williamson deserves the highest status that we grant non-nationals the right to be Caymanian. Mr. Speaker, Mr. Williamson is a 27-year-old Jamaican national who has resided in the Cayman Islands since 2007. He lives in Grand Cayman and has other immediate family that reside locally. He arrived here at the age of 13 and was added as a dependent to his mother's residency and employment rights certificate as the spouse of a Caymanian. Mr. Williamson resides with his mother's stepfather, half-brother, and half-sister. While resident in the Cayman Islands, he completed compulsory education at Cayman Academy, John Gray High School, and Clifton Hunter High School. He then acquired a student visa to pursue studies at University College. While living in the Cayman Islands, he has been a model student and has represented the Cayman Islands in athletics as well as in the Cayman Islands Cadet Corps. He also plays an important role in the care of his younger siblings and has developed a strong relationship with both of them. He has no close family left in Jamaica except for a grandmother with whom he has not maintained a relationship. He intends to continue his studies overseas at the New England Institute of Technology, where he has been accepted to study electrical engineering. He hopes to return to Cayman, which he considers home, with these qualifications to work in areas having to do with improvement of infrastructure. Mr. Speaker, in 2011, his mother and stepfather sought advice from the then Department of Immigration on Mr. Williamson's options prior to him turning 18. They have advised that all that was necessary was for his passport to be restamped. The terms of his mother's residency and employment rights certificate specify that her dependent could reside in the islands until attaining the age of 18, or if they were pursuing full-time tertiary education until they attained the age of 24. or completed their education, whichever was earlier. His mother, however, was unaware of the consequences of applying for Caymanian status for herself without her dependent having PR in his own right. In May 2013, his mother applied for Caymanian status, and at that time, the young man, Mr. Williamson, had been living in the Cayman Islands for less than 6 years, which is not long enough to meet the minimum time for being legally and ordinarily resident to apply for permanent residence. After his mother submitted her application for status, a lengthy period of time passed without her receiving notification from the board. Mr. Williamson's mother visited the Immigration Department in April 2014 to have his passport stamp updated and was informed of the following. She had in fact been granted status in June 2013. She was in arrears of $1,000 as she was no longer a residence and employment rights certificate holder. The young man, her son, was no longer a dependent of such a holder. That is, he was no longer a dependent of an RERC holder. Mr. Speaker, Mr. Williamson made the following applications. In April 2014, he applied for time from the Immigration Department. However, his application was rejected by the board on the basis that he did not meet the eligibility criteria, as he ceased to be a dependent on his mother's permanent residence as of 30th of May 2013, when she was granted status. He then applied for and was granted a student visa that allowed him to remain in the islands, finalizing his studies at UCCI. He then, through Cayman Immigration Consultancy Services, submitted a fresh application for permanent residency in February of 2016, pursuant to Section 32 of the Immigration Law, which was again refused in January 2017 on the basis that he did not meet the relevant legal and ordinary resident criteria under the relevant section of the law. In April 2017, he applied to remain in the Cayman Islands until his 24th birthday as the dependent of his mother and stepfather. However, that application was rejected on the basis that he did not satisfy the narrow definition set out in Section 6712 of the law. In June of 2017, he applied to the board for support for their recommendation that he be, or their recommendation to Cabinet that he be granted the right to be Caymanian. In December 2017, he received a letter indicating that the board was not minded to make such a recommendation on the basis that, quote, his circumstances were not unique to others in a similar situation. It was observed that Mr. Williamson has other options to continue to reside and work in the islands, and a recommendation to Cabinet is not appropriate in this case, quote unquote. Mr. Williamson appealed this decision to the Immigration Appeals Tribunal, which determined in July 2019 that he qualified to appeal, and they granted the appeal and forwarded the recommendation for the right to be Caymanian to the Cabinet. Additionally, it was determined that Mr. Williamson had a right to family life under Article 9 of the Bill of Rights, as his Caymanian half-siblings would not benefit from his absence from the islands. Mr. Speaker, Mr. Williamson has been in a situation where he has attempted to regularize his immigration status by applying for permanent residence on 2 occasions, but because of the unique situation he finds himself in, he cannot meet the minimum residency eligibility requirements. And he cannot remain in the Cayman Islands to do so because he does not satisfy the definition of a dependent as outlined in Section 67 of the law. Mr. Speaker, it should be noted that the definition of dependent in the Immigration Transition Law is not as prescriptive as in the 2015 revision and would not limit Mr. Williamson in the same manner. However, the requirement to be legal and ordinary resident for 7 years immediately prior to the application for PR remains in place, and due to him technically being illegally resident here between May 2013 and April 2014, when his mother's status was approved, he remains ineligible for PR. Mr. Speaker, Mr. Williamson has no other dependents that will be entitled to reside in the Cayman Islands or become Caymanian. He has met all other requirements in terms of criminal records, financial history, and medical well-being. In addition, Mr. Speaker, he has provided a series of noteworthy Caymanian references in support of his application, namely from Coach Tyrone Yen, Wendy Fisher, Darren Ebanks, and Kimberly Bolt. Mr. Speaker, while Mr. Williamson has options to remain under the work permit regime, his application for PR and onward to Caymanian status remains unavailable to him at this time. Cabinet is therefore of the opinion that he has sufficiently demonstrated that the Cayman Islands is his home, having remained here for the last 13 years and having close family connections whom he resides with. Cabinet is satisfied that Mr. Williamson is committed to the islands in his current education and future professional goals, and therefore his application warranted the special consideration provided for under this facility. Mr. Speaker, it is for the foregoing reasons that the Immigration Appeals Tribunal recommended to Cabinet Mr. Williamson's application for the right to be Caymanian by way of Cabinet grant. Furthermore, Mr. Speaker, the Cabinet supported the recommendation of the Tribunal as the Cabinet recognizes Mr. Williamson's peculiar situation and future values the Cayman Islands and our community. There is no doubt, Mr. Speaker, that Mr. Kirk Williamson is deserving of consideration of being granted the right to be Caymanian in accordance with the provisions of the Immigration Transition Law 2018, Mr. Speaker, and I commend this motion to the House.
Does any other member wish to speak? Does any other member wish to speak? If no other member wish to speak, I'll call on the Premier.
Thank you, Mr. Speaker. Simply to thank all honorable members of the House for their tacit support of the motion.
Question is, be it therefore resolved that the immigration grant of the rights to be Caymanian Order 2020 be affirmed by the Parliament pursuant to the provisions of Section 26(1)(c) of the Immigration Transition Law 2018. All those in favor, please say aye. Aye. Those against? The ayes have it. Government motion number 2 has been passed.
Government motion number 3 of 2020-2021, Immigration Transition Law 2018, the Immigration Grant of the Right to be Caymanian, number 2 Order 2020, to be moved by the Honourable Minister of Employment, Border Control, Community Affairs, International Trade, Investment, Aviation, and Maritime Affairs.
You can just say Premier, you know.
The Honorable the Premier.
That's a handful, a mouthful. That's all right. I'll manage. Thank you, Mr. Speaker. Mr. Speaker, I beg to move Government Motion number 3 for the 2019-2020 session, entitled Immigration Grant of the Right to be Caymanian, number 2 Order 2020. Whereas 26(1)(e) of the Immigration Transition Law 2018 provides that the Cabinet, acting upon the recommendation of the Cayman Status and Permanent Residency Board, may grant the right to be Caymanian in accordance with the section. And whereas Section 26(1)(e) provides that such grant shall be ratified by the Parliament, and whereas the Immigration Grant of the Right to be Caymanian, number 2 Order 2020 was laid on the table of the Parliament, be it therefore resolved that the Immigration Grant of the Right to be Caymanian, number 2 Order 2020, be affirmed by the Parliament pursuant to the provisions of Section 26(1)(c) of the Immigration Transition Law 2018.
Question is, be it therefore resolved that the immigration grant of the right to be Caymanian, number 2 Order 2020, be affirmed by the Parliament pursuant to the provisions of Section 26(1)(c) of the Immigration Transition Law 2018. Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, this motion is being brought in relation to the Cabinet grant of the right to be Caymanian to Ms. Calicia Barborum in compliance with 26(1)E of the Immigration Transition Law 2018. Mr. Speaker, in October 2018, an application was made to the Caymanian Status and Permanent Residency Board, who then advised Ms. Barborum that her application was being recommended for the grant of the right to be Caymanian, recommended to the Cabinet. This application was approved by Cabinet at a recent meeting, and Cabinet has requested that the decision be forwarded to the Parliament for ratification. Mr. Speaker, Calicia Barborum is a 39-year-old Jamaican national who has resided in the Cayman Islands since 1990. She lives in Grand Cayman with her Caymanian daughter and has other immediate Caymanian family who also reside locally. She arrived in these islands in July 1990 at the age of 9, accompanied by her mother and her brother. Ms. Barborum completed her compulsory education in the public school system and represented the Cayman Islands in track and field events overseas while she was a student at John Gray. She has been employed by the Cayman Islands government since 1999 and is currently employed by the Criminal Investigation Department of the Royal Cayman Islands Police Service. Throughout her professional career, she has regularly sought out continued education, completing certificates in business administration and executive global leadership at the University College, and more recently, the LLB honors degree at Truman Bodden Law School in 2014. She has also completed various professional certifications related to her field. Mr. Speaker, she is passionate about her role in protecting the citizens of these islands and excels in her role within the Royal Cayman Islands Police Service, as evidenced by her 2013 Outstanding Service Award as Police Officer of the Year. In 2014, she was awarded the Cayman Islands Heroes Day Citation for bravery for exceptional courage in keeping the Cayman Islands community safe. She has also made numerous personal contributions to the community through her active membership in the Rotary Club of Grand Cayman Central and its sponsored club Rotaract Blue, whereby she volunteered her time for many community service projects and was Director of Community Service from 2017 to 2018 and Director of Youth Services from 2018 to 2019. A reference from the Secretary to the Board of Directors from 2018 to 2019 also states that Ms. Barborum was also fundamental to several of Rotary Central's recurring projects like the Music Extravaganza, Science Fair, Take a Kid Fishing, and literacy projects, among others. Mr. Speaker, Ms. Barborum's family ties in the Cayman Islands remain current, as both her mother and brother reside permanently in the islands and possess the right to be Caymanian. She also has a daughter who was born in the islands in 2001 to a Caymanian father. She is settled in these islands and considers the country to be her home. Indeed, she has been here for 39 years. She and her brother are the registered owners of an apartment in the La Serenidad development in the Savannah area, purchased in 2012 for $160,000. She's also the registered proprietor of a second property in the Spots area. Mr. Speaker, Ms. Barborum has no other dependents that would be entitled to reside in the islands or become Caymanian. She has met all other requirements in terms of criminal records, financial history, and medical well-being. She's provided a series of noteworthy Caymanian references in support of her application, namely from Dr. Sidney Ebanks, Ms. Yvette Cacho, Mr. Colin Redden, Mr. Bernie Bush, and Reverend John K. Evans, Jr. Mr. Speaker, at the time of Ms. Barborum's application, the Immigration Law 2015 revision was in place, which required applicants for permanent residency to submit their applications after residing in the islands for a minimum of 8 years, however, no later than 9. Given that Ms. Barborum's application was submitted after approximately 18 years in the Cayman Islands, her application was initially found to be ineligible. Section 37 of the Immigration Transition Law 2018 now provides for an applicant to apply for permanent residency after they're legal and ordinary resident in the Cayman Islands for 8 years. While Ms. Barborum's application is no longer ineligible under the previous law, Cabinet was of the opinion that her demonstration of commitment to the islands, both personally and professionally, over the past 3 decades warranted the special consideration provided for under this facility. Mr. Speaker, it is for the foregoing reasons that the Caymanian Status and Permanent Residency Board recommended to Cabinet Ms. Barborum's application for the right to be Caymanian by way of a Cabinet grant. Furthermore, Mr. Speaker, Cabinet supported the recommendation of the board as we recognize Ms. Barborum's value to the Cayman Islands and our community. There is no doubt, Mr. Speaker, that Ms. Calicia Barborum is deserving of consideration of being granted the right to be Caymanian in accordance with the provisions of the Immigration Transition Law 2018.
Question is, be it therefore. Does any other member wish to speak? The Honorable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I wanted to speak on the other one, but I'm glad I didn't now because I don't know one of the other individuals on this, and I believe that's a young person too, Lewis. That's one of those, I guess. Mr. Speaker, we could be here in this house forever, and we will never cover all of the people in this country under similar circumstances. That's the reason they have been calling them ghost Caymanians. I have been preaching this forever. Mr. Speaker, the government of 2005 to 2009 changed the immigration law to put these provisions in place. And there were special circumstances. They were designed for Cabinet to only issue 4 per year for special circumstances. These would at the time consider extraordinary circumstances. It is occasions like this that we should not even think of it as being special circumstances. We need to do something to regularize these people. They have no place to go. They have no one to go to. And they wait for years for Cabinet to be able to bring it here. No fault to Cabinet. Many times, Mr. Speaker, it's them not being of any understanding of the law, but other times it is the system that prevents them from becoming permanent structures, entities in this country. I have a young lady, a gentleman in East End who's married to a Honduran national who had a child prior to the marriage. They since had a child, another daughter. He attempted to adopt that child shortly after the marriage. The child is a student. He applied for adoption, asked myself and other upstanding citizens in the society to give him reference letters on his family life and the child and whatnot. We all did. Mr. Speaker, our letters were all rejected, and we didn't know. Why were they rejected? Because we all gave them to him, and he delivered them with his application. That took 1 year or more for us to find out that we had to seal it and deliver it in person. That child is now, because it took so long to get the permission from Honduras and the translation of those documents, that child is now in the same category as these children that we are doing here today. And that's not the only one. There are many like that. If we do not do something, only the few are going to be regularized through this process. They have no place to go. And they all have a right to the family life as defined by the Bill of Rights. That gentleman from East End has a right to form a family. I do not believe cabinet should have to be bothering themselves with this. It's absolutely unnecessary. And then we create this stigma that hangs with these children forever. They have their other siblings that are born Caymanians. We create the stigma on them that they will never erase. They will never erase it. And they're running to and fro trying to regularize themselves until all options are exhausted. Then they have to run to cabinet. And then people call them ghosts and whatnot. Yet, this gentleman in East End, his wife applied for Cayman status. And the child is a dependent on her RERC. Going to be in the same situation that the previous one was in. Cabinet should not have to be bothering themselves with this. The processes are so long to get to that point. Mr. Speaker, I don't think that it is overly burdensome, the amount of those that are here in that situation. There are other situations where Caymanians who have ties here, their children who came here with them, or people from overseas who have Caymanian ties and came here, in particular those from the Bay Islands, where we have a close connection. Their children are in the same situation. They're 30, 40 years old. And we can't get them regularized. Somehow we need to ensure that we do something different than burdening cabinet with these situations. I don't know how we're going to do it, but I'm sure the AG can find some way to do some presentation to this cabinet, this parliament. I know, Mr. Speaker, we recently made provisions to put back in the immigration law that sunset clause which gave them the right to apply. But I don't think that is the only answer. If that was the only answer, Cabinet wouldn't be recommending for each year. And I doubt we'll capture your situation, but at the very least, it would cut down some of those that cabinet has to consider. I want to see, and my thing is, I implore the government again to look at somewhere that we can some different way to regularize some of these people in these situations. We just did too, with the same situation. Something needs to be done. I thank you, Ms.
President, the member for Bordentown West.
Thank you, Mr. Speaker. I must say that officer has been very active in the community, and she has also been, I think, placed there several times since we have been, since I've been elected at least. I know she does a lot of work with Rotary. And just to kind of expand on what the Honorable Leader of Opposition said, I think it's clear that we definitely need to make some more changes to our immigration law, because that's a clear example of what the Premier outlined in terms of someone deserving of Caymanian status. And to be here 30 of 39 years and with such a community record, is basically means that there's definitely some kind of loophole or something still missing within immigration law. I know it is something that we definitely won't get right, but at a minimum, I think it's definitely something that we need to look at. But I really want to thank the government at least for fixing that one, and applaud the cabinet for making that decision in terms of such a worthy person for Caymanian status. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? If not, I'll call on the Premier.
Mr. Speaker, I thank the Leader of the Opposition and the member for Bordentown West who have spoken. Mr. Speaker, I'm not going to get into that long and storied debate this evening because it is so late, but the members have a point. We'll never, I don't think, ever have a perfect piece of immigration legislation. No country in the world ever does. So you're constantly tweaking it, trying to address issues. But I am thankful that we do have this provision in the law that allows for those cases for which there appear to be no proper resolution in the law to be dealt with. I can indicate, Mr. Speaker, that we still have a few which we hope to deal with early in the next year, because we're limited to 4 per year. But the queue is not very long now. We've worked through them because every year since we've been in office, we've brought forward the maximum that we can. Mr. Speaker, yeah, we need to vote.
Question is, be therefore resolved that the immigration grant of the right to be Caymanian number 2 order 2020 be affirmed by the Parliament pursuant to the provisions of section 26(1)(c) of the Immigration Transition Law 2018. All those in favor, please say aye. Aye. Those against, the ayes have it. Government motion number 3 has passed.
Government motion number 4 of 2020-2021, the Immigration Transition Law 2018, the Immigration Grant of the Right to be Caymanian number 3 order 2020, to be moved by the Honorable Premier.
Honorable Premier.
Mr. Speaker, I beg to move Government Motion Number 4 of the 2019-2020 session entitled Immigration Grant of the Right to be Caymanian Number 3 Order 2020. Whereas Section 26(1)(e) of the Immigration Transition Law 2018 provides that the Cabinet, acting upon the recommendation of the Cayman Status and Permanent Residence Board, may grant the right to be Caymanian in accordance with the section. And whereas Section 26(1)(e) provides that such grant shall be ratified by the Parliament. And whereas the immigration grant of the right to be Caymanian number 3 Order 2020 was laid on the table of the Parliament, be it therefore resolved that the immigration grant of the right to be Caymanian number 3 Order 2020 be affirmed by the Parliament pursuant to the provisions of Section 26(1)(e) of the Immigration Transition Law 2018.
Question is, be it therefore resolved that the immigration grant of the right to be Caymanian number 4 order, is it?
Number 3.
Number 3 order? Number 4.
No, number 3. It's number 3.
Oh, Lord.
Mr. Chairman, it is the immigration grant of the right to be Caymanian number 3 Order 2019.
Be it therefore resolved that the immigration grant of the right to be Caymanian number 3 Order 2020 be confirmed by the Parliament pursuant to the provisions of Section 26(1)(c) 1. I've been saying 1C. Is it 1C or 1E? Okay, let's have another go at this then. Be therefore resolved that the immigration grant of the right to be Caymanian number 3 Order 2020 be affirmed by the Parliament pursuant to the provisions of Section 26(1)(e) of the Immigration Transition Law 2018. Premier.
Thank you, Mr. Speaker. Mr. Speaker, this motion is brought in relation to the Cabinet grant of the right to be Caymanian to Mr. Glenville Lewis in compliance with 26(1)(e) of the Immigration Transition Law 2018. Mr. Speaker, in July 2018, an application was made to the Caymanian Status and Permanent Residency Board for the right to be Caymanian for Mr. Lewis. However, in March 2019, the Caymanian Status and Permanent Residency Board deferred the application and made a recommendation to Cabinet for the grant of the right to be Caymanian. Mr. Speaker, in November 2020, Cabinet approved the recommendation for Mr. Lewis to be granted the right to be Caymanian and requested that the decision be sent to the Parliament for ratification. Mr. Glenville Lewis is a 53-year-old Jamaican national who has resided in the Cayman Islands since 1995, 25 years. The applicant lives in Grand Cayman with his wife, Dolores Lewis. While the applicant has been in the Cayman Islands, he has maintained employment as a landscaper, employed by Mr. Charles Lewis McFeel and Mr. Alvin McLaughlin for the last 13 years. Although he has resided and worked in the Cayman Islands community for far longer than the time required to apply for permanent residence, he was originally denied permanent residence because he could not afford any property or investments. Mr. Speaker, the Board has therefore identified Mr. Lewis as a person of unique circumstances, deserving of consideration as being granted the right to be Caymanian in accordance with Section 26(1)(e) of the Immigration Transition Law 2018 for the following reasons. His application for permanent residence was denied, and so was the appeal. He has been on the island for more than 20 years, and although he seemingly has no investment in property, he has a clear police record and his references speak very highly of him. Mr. Speaker, while there is no evidence of ownership of property and investments, Mr. Lewis is soundly employed and unlikely to be a burden on the Cayman Islands society. Mr. Speaker, pursuing Caymanian status via the work permit and permanent residency regime has been explored by Mr. Lewis, and he has not been successful. It appears that qualifying via the Cabinet grant provision is his only option. Mr. Speaker, it is for the foregoing reasons that the Caymanian Status and Permanent Residency Board recommended to Cabinet Mr. Lewis's application for the right to be Caymanian by way of Cabinet grant. There is no doubt that Mr. Lewis is deserving of consideration of being granted the right to be Caymanian in accordance with the provisions of the Immigration Transition Law 2018. Mr. Speaker, if I might just add that the regime that is currently in place was put in place to avoid situations arising such as this, where persons are left in a state of uncertainty for extended periods of time. I've always been of the view that when a person is allowed to remain in your country for such extended periods of time, regardless of what their circumstances are, you simply cannot kick them out, and that you have to find a means of ensuring that they have security of tenure and the opportunity to look after themselves and their family. So I am not, Mr. Speaker, certain how this individual immigration status seemingly fell between the cracks, and that he was not granted permanent residence, but permitted to stay here for such an extended period of time, now 25 years. And so while I know there will be concerns, if not in this Parliament, certainly in the broader community, because of the lack of investments and so forth, the reality is that Mr. Lewis and his wife and family are clearly part of the fabric of this society now, and are making their way through life, and certainly deserve, after that length of time, the opportunity to do so as Caymanians.
Does any other member wish to speak? Does any other member wish to speak? Call on the Premier to write a reply or to wind up the motion. No, that's a reply.
Getting a bit fatigued.
Yes.
I couldn't remember if we voted or not. Mr. Speaker, just to thank members for their tacit support for the motion.
The question is, be it therefore resolved that the immigration grant of the right to be Caymanian number 3 order 2020 be affirmed by the Parliament pursuant to the provisions of section 26(1)(e) of the Immigration Transition Law 2018. All those in favor, please say aye. Those against, the ayes have it. Government motion number 4 has been passed.
Government motion number 5, Immigration Transition Law 2018, the Immigration Grant of the Right to be Caymanian, number 4 order 2020.
Honorable Premier.
Sorry, is somebody calling me?
Mr. Speaker, I beg to move government motion number 5 of the 2019-2020 session, entitled Immigration Grant of the Right to be Caymanian number 4 order 2020. Whereas section 26(1)(e) of the Immigration Transition Law 2018 provides that the Cabinet, acting upon the recommendation of the Cayman Status and Permanent Residency Board, may grant the right to be Caymanian in accordance with the section. Whereas section 26(1)(e) provides that such grant shall be ratified by the Parliament, and whereas the immigration grant of the right to be Caymanian number 4 order 2020 was laid on the table of the Parliament, be it therefore resolved that the immigration grant of the right to be Caymanian number 4 order 2020 be affirmed by the Parliament pursuant to the provisions of section 26(1)(e) of the Immigration Transition Law 2018.
Question is, be it therefore resolved that the immigration grant of the right to be Caymanian number 4 order 2020 be affirmed by the Parliament pursuant to the provisions of section 26(1)(e) of the Immigration Transition Law 2018. Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, this motion is being brought in relation to the Cabinet grant of the right to be Caymanian to Mr. Andre Mondesir in compliance with Section 26(1)(e) of the Immigration Transition Law 2018. Mr. Speaker, in August 2018, an application was made to the Cabinet with the support of the Caymanian Status and Permanent Residency Board for the right to be Caymanian for Mr. Andre Mondesir. The application was initially deferred. However, at its most recent meeting when these matters were discussed, Cabinet approved the recommendation for Mr. Mondesir to be granted the right to be Caymanian and requested that the decision be sent to the Parliament for ratification. Mr. Speaker, Mr. Andre Mondesir is a 52-year-old native of Trinidad and Tobago who initially came to the Cayman Islands in 2002 as a senior Crown Counsel with the Cayman Islands Government Legal Department. During his time at the Legal Department, Mr. Mondesir prosecuted and represented the Crown in many serious and complex cases involving organized crime. He was able to successfully prosecute the majority of those cases successfully, which resulted in a reduction in serious crimes during his tenure with that department. Mr. Speaker, Mr. Mondesir was also responsible for the administration of all matters brought before the summary, youth, and juvenile courts in the Cayman Islands and played a major role in the development of policies for the division. In October 2007, Mr. Mondesir joined the legal division of the Cayman Islands Monetary Authority as legal counsel, where he provided legal and policy advice, was responsible for litigation on behalf of SEMA, and was actively involved in the AML-CFT issues, as well as the preparation of the authority's IOSCO application. He left SEMA later in 2008 to become one of the youngest judges on the Supreme Court of Trinidad and Tobago, where he remained for the following 5 years. Mr. Speaker, Mr. Mondesir returned to the Cayman Islands in March 2013, where he was appointed as Deputy General Counsel of SEMA, where he coordinates and manages the day-to-day operations and projects of the legal division. Mr. Mondesir provides directives and guidance to the legal staff on litigation and all aspects of research, preparing opinions and dispensing advice on a wide range of regulatory and financial services matters. His role also includes, among other things, providing advice and guidance to the Compliance Division on the full range of enforcement matters, as well as providing legal advice, guidance, and leadership to the various supervisory divisions on matters relating to local and international financial services regulation. His areas of responsibility include providing legal advice on bank controllerships and liquidations, money services business, licensing and regulation of insurance business, fiduciary services, as well as investments and securities matters. Mr. Speaker, in his capacity as lead counsel, Mr. Mondesir is also responsible for conducting all serious and high-profile litigation on behalf of SEMA, and has delivered speeches both locally and international on a range of topics, including mitigating the ongoing risks of correspondent banking, the Directors' Registration and Licensing Law 2014, and regulatory enforcement in the Cayman Islands. Over the years, Mr. Speaker, Mr. Mondesir has been actively involved in teaching various areas of the law on a part-time basis at the University of the West Indies and other private tertiary institutions. During that time, he also served as a senior legal advisor and staff judge advocate for the Trinidad and Tobago Defense Force. It was due to this previous experience that Mr. Mondesir initially volunteered with the Royal Cayman Islands Police Service as a special constable during his first stint in the Cayman Islands, and was able to offer critical expertise in preparation for and during Hurricane Ivan in 2004. Due to his professional capacity and unique knowledge of military law, he provided the legal guidance under which national decisions were made as they pertain to curfew and the scope of police power under the state of emergency. Additionally, Mr. Speaker, Mr. Mondesir volunteered alongside other officers, bravely rescuing families who were in imminent danger despite the great risk to his personal safety. Additionally, Mr. Speaker, Mr. Mondesir continues to be involved in the local community. He was appointed as a member of the Cadet Corps Advisory Committee in 2005 and continues to serve the committee in the capacity of chairman and offers the young cadets guidance and support where necessary to enhance the organization. Mr. Speaker, Mr. Mondesir was also appointed to serve as legal advisor for the Cayman Islands Regiment in 2019, having a history with the Trinidad and Tobago Defense Force, as previously mentioned. In this capacity, key duties include providing expert advice and strategic support to leadership and key stakeholders on relevant matters of law, policy, and procedure. In collaboration with the Legislative Drafting Department, Mr. Mondesir was the Cayman Island Regiment's lead for the drafting of the Defense Bill 2020, which was recently passed in this House, which provides legal footing for the establishment and operation of the Cayman Islands Regiment. Mr. Mondesir is also the regiment's lead for the drafting associated with the governor's orders, which provide the regulatory, policy, and procedural frameworks necessary to support efficient and effective operations, including administration, discipline, training, and deployment. Mr. Speaker, in spite of his contributions and active role in investing and developing in the Cayman Islands for over 16 years, Mr. Mondesir has never acquired status and has remained here on other immigration facilities. The Caymanian Status and Permanent Residency Board recognize his significant expertise and contributions to the Cayman Islands he has made through his legal profession, as well as the demonstration of his spirit of volunteerism whilst performing his duties as a special constable to the benefit of the people of the Cayman Islands during the passage of Hurricane Ivan. As such, on the 26th of July 2008, the Caymanian Status and Permanent Residency Board recommended Mr. Mondesir as a suitable candidate to be considered for the grant of the right to be Caymanian under Section 21E of the Immigration Law 2015 revision, now 26(1)E of the Immigration Transition Law 2018. Mr. Speaker, Mr. Mondesir has provided a series of noteworthy Caymanian references in support of his application, namely from Mr. Langston Sibley's, Mr. Peter Pollack, Mr. Jeff Jackson, and Mr. Anthony Innes. Mr. Speaker, Section 37 of the Immigration Transition Law 2018 provides for an applicant to apply for permanent residency after they are legally and ordinarily resident in the Cayman Islands for 8 years. Mr. Mondesir's departure from Cayman in 2008 and return in 2013 means that the starting time for his minimum term can only be counted from March 2013. While the work permit and permanent residency regime may be available to Mr. Mondesir in the future, Cabinet felt that his demonstration of commitment to the islands over 13 of the last 18 years warranted the special consideration provided for under this facility. Mr. Speaker, it is for the foregoing reasons that the Caymanian Status and Permanent Residency Board recommended to Cabinet Mr. Mondesir's application for the right to be Caymanian by way of a Cabinet grant. Furthermore, Mr. Speaker, my Cabinet colleagues supported the recommendation of the Board as we recognize Mr. Mondesir's value to the Cayman Islands and our community. There is no doubt, Mr. Speaker, that Mr. Mondesir is deserving of consideration of being granted the right to be Caymanian in accordance with the foregoing provisions of the Immigration Transition Law 2018.
Does any other member wish to speak? Does any other member wish to speak? The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, just rise to lend my support to the motion on behalf of Mr. Andre Mondesir, a colleague. Mr. Speaker, as you heard from the Honorable Premier, he had a stint, if I might put it that way, a tenure with us at the Government Legal Department in Chambers. He was an invaluable colleague, Mr. Speaker. And I would describe him as the quintessential professional, very able lawyer, extremely courteous and feeling courteously towards colleagues and as well as others, Mr. Speaker. And he is a very passionate person about what he does. Mr. Speaker, I can't think of a more deserving person for consideration for the right to be Caymanian. Mr. Speaker, I can speak personally to his efforts during Hurricane Ivan when we were in all sort of turmoil in terms of security. And Mr. Speaker, he volunteered. I saw him personally patrolling with police officers in trying to maintain law and order even at the expense of his own family at times. And so, Mr. Speaker, I can attest to that. And yes, of course, this is all probably consistent with his training, Mr. Speaker, and his service as in the military in Trinidad. And him, of course, no surprise, volunteering to assist here with the Cadet Corps, and in more recent times, Mr. Speaker, the regiment, Mr. Speaker. He is very passionate about these things. Mr. Speaker, he has a wonderful family, Dr. Michelle Monsieur and two daughters, a family practitioner. And they really consider Cayman their home. They made contribution and continue to make contribution to these islands, Mr. Speaker. And I think it will be an excellent gesture, Mr. Speaker, for him to be afforded the opportunity of being considered and recognized as a Caymanian, Mr. Speaker. So, Speaker, I hadn't mentioned his ongoing effort as we speak as General Counsel of SEMA, where he is also helping to spearhead the ongoing effort to ensure that our anti-money laundering CFT framework complies with international standard, Mr. Speaker. He continues to lead from the front in that regard as well. So his dedication, commitment, and service to these islands, Mr. Speaker, is certainly without question. So Speaker, I hadn't spoken earlier about Ms. Kalisha, who is also a very deserving candidate, the Premier mentioned for earlier on, a police officer, and also a most deserving candidate in my view. So, Mr. Speaker, I certainly would wish to lend my support to the motion in respect of that. Thank you.
Does any other member wish to speak? Does any other member wish to speak? If not, I'll call on the Honorable Premier to wind up.
Thank you, Mr. Speaker. To thank the Honorable Attorney General for his contribution. I believe all members of this House are acquainted, some more so than others, with both Ms. Barborum and with Mr. Mondesir, and are well aware of their significant and continuing contributions to the country. They are already part of the fabric of this country, and I believe all members will join with me in welcoming them as part of the Caymanian family in the truest sense of that expression.
I thought whether, as presiding officer, I should say anything, and I know I don't supposed to say, but I want to say and I should say, because Mr. Mondesir is and his family are citizens and residents of West Bay, and they are good people for our community. I laud the government for finally getting the motion here. And I thank the government. We need, if we're going to grow people, we need people that can help us continue good character, good moral people. His wife is a doctor in our community, has her office in our community. I think the only doctor in the district at the clinic except for the government clinic. So they have invested strongly in West Bay. I'm proud of them, glad to know them. They're, as I repeat, an excellent family. Question is, be therefore resolved that the immigration grant of the right to be Caymanian number 4 order 2020 be affirmed by the Parliament pursuant to the provisions of section 26(1)(e) of the Immigration Transition Law 2018. All those in favor, please say aye.
Aye.
Those against? The ayes have it. Government motion number 5 has passed.
Government motion number 6, issuance of a deed of indemnity, Cayman Islands Legal Practitioners Association and the Cayman Attorney Regulatory Authority, to be moved by the Honorable Attorney General.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, it's getting late and voices coming under a bit of pressure. Mr. Speaker, I beg to move government motion number 6 of 2020, issuance of a deed of indemnity, Cayman Islands Legal Practitioners Association and Cayman Attorneys Regulatory Authority. The motion reads, Mr. Speaker, whereas the government of the Cayman Islands is desirous of issuing a deed of indemnity to the members of the board of directors of SILPA and CARA as the attached deed of indemnity stipulates. And whereas Section 8 of the Public Management and Finance Law provides that as a general rule, no guarantee may be given by or on behalf of the government unless it has been authorized by a resolution of the Legislative Assembly, be it now therefore resolved that the Legislative Assembly hereby authorizes the issuance to members of SILPA's board and CARA of a deed of indemnity guarding against the potential liability of members of SILPA's board and CARA. Thank you.
Question is, be it now therefore resolved that the Legislative Assembly here remember we said Legislative Assembly, but it's taken to be the Parliament. So do we leave it? Be it now therefore resolved that the Legislative Assembly here authorizes the issuance to members of SILPA's board and CARA of a deed of indemnity guarding against the potential liability of members of the SILPA's board and CARA. The Honorable the AG.
Thank you, Mr. Speaker. Mr. Speaker, it came down before the changes to the title of Parliament. Mr. Speaker, this motion is being brought pursuant to Section 8 of the Public Management and Finance Law. Mr. Speaker, because of the deficiencies identified by the Cayman Islands Mutual Evaluation Report during the review by the CFATF in 2017, it became necessary to put in place an anti-money laundering and combating financing of terrorism regulatory framework for Cayman Islands attorneys at law. The CFATF, Mr. Speaker, the report identifies the absence of a supervisory body to regulate attorneys for AML-CFT as a weakness in the Cayman Islands overall AML-CFT framework, and therefore a deficiency in recommendation 1, among others, and, Mr. Speaker, also a deficiency in a number of immediate outcomes. Accordingly, Mr. Speaker, in a bid to address this very significant weakness, the legal practitioners law was amended to allow for, among other things, the creation of a self-regulatory body, SRB, to supervise attorneys for compliance with AML CFT matters, Mr. Speaker. Mr. Speaker, the designation as an SRB was made pursuant to Section 4.9 of the Proceeds of Crime Law, which provides that the Cabinet may assign to the Financial Reporting Authority, a public body, or a self-regulatory body, the responsibility of monitoring compliance with money laundering regulations made under that law in relation to persons conducting relevant financial business who are not otherwise subject to such monitoring by the Cayman Islands Monetary Authority. Mr. Speaker, pursuant to this provision, the Cabinet on the 19th of February 2019 formally designated SILPA as the self-regulatory body responsible for monitoring attorneys for AML CFT matters. SILPA, Mr. Speaker, is an incorporated body of Cayman Islands attorneys at law. The government has been advised that it represented between 85 to 90% of the attorneys in the Cayman Islands, which amounts to anywhere between 750 and 800 lawyers, Mr. Speaker. The designation of SILPA by the Cabinet as a self-regulatory body for attorneys is similar, Mr. Speaker, to what has been done with the Cayman Islands Institute of Accountants, CIPA, which has also been designated as a SRB for accountants. Mr. Speaker, in order to create a separation between SILPA and the actual regulators, that is, the attorneys who do the actual regulatory MLCFT oversight, SILPA amended its memorandum and articles of association to allow for the delegation of such duties to a sub-agency of SILPA. This body, Mr. Speaker, is known as CARA, which consists of 2 dedicated attorneys and a support personnel, Mr. Speaker, who are responsible for this initiative. CARA, Mr. Speaker, CARA largely operates as a self-autonomous body in performing its AML-CFT supervisory functions. Mr. Speaker, this makes good sense, as CARA is responsible for the oversight of all the attorneys who are members of SILPA and whose practice of law involves what is known as relevant financial businesses, which is the trigger point, Mr. Speaker, for AML-CFT supervision. That is, Mr. Speaker, only attorneys who are involved in relevant financial businesses are supervised by CARA for AML-CFT as required by the relevant FATF recommendations. This creation and designation of SILPA, Mr. Speaker, /CARA and SIPA relieve the government of the duty or necessity of having to create, Mr. Speaker, public body or bodies staffed by specialist public officers to carry out these AML-CFT supervision. Mr. Speaker, had the public body been created and staffed with government employees, they would have benefited from the usual immunity and indeed requisite indemnity enjoyed by public officers, Mr. Speaker. Mr. Speaker, CARA, on behalf of SILPA, are in effect, or CARA, and by extension SILPA, are in effect performing the AML-CFT monitoring public functions effectively on behalf of the state. Mr. Speaker, they do not enjoy indemnity from legal exposures for performing these roles. It is against this background, Mr. Speaker, that Parliament is being asked to agree that they be given indemnity by government in the performance of their role of supervisor of attorneys for AML-CFT purposes. Mr. Speaker, the scope of the indemnity is confined to the board of directors, past and present, to whom CARA is directly answerable. That is, Mr. Speaker, not the entire membership of SILPA that is being covered. It would be confined to the board of CARA and, as outlined in the attached draft deed of indemnity. Mr. Speaker, in terms of the indemnity, the terms of the indemnity are generally in identical terms to those granted to the Board of Cayman Airways and some other similar government entities, including the Liquor Licensing Board, Mr. Speaker, and presupposes that the carrying out of these duties as supervisor for ML matters, they act in good faith. Mr. Speaker, the deed of indemnity was authorized by Cabinet on the 24th of November 2020. But as stated earlier, Section 8 of the PMFL stipulates that no guarantee can be given by or on behalf of the government unless it has been approved, Mr. Speaker, by a resolution of this Parliament. Mr. Speaker, I commend this motion to honorable members of this House for their support. Thank you.
Any other member wish to speak? The Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, I guess I have to question why this is coming at this time. And the other question that begs is, which other government authority we are going to give indemnity to? Will the accountants be given indemnity who are a regulatory authority as well? Mr. Speaker, why I ask why at this time is because, one, there are a number of lawsuits filed by attorneys in this country against Cara, I know in particular. I don't know if, and I believe Silpa as well. Why wasn't this done at the time that they were being given the supervisory authority under the Proceeds of Crime Law? 4.9, I think it is. Mr. Speaker, it is suspicious, and I want to know what has caused government to all of a sudden come up with an indemnity for a company / authority, if it is such a creature, as its name, because it's not regulated by the Public Authorities Law, as far as I know. Yet it can carry the name authority. And we are now giving them indemnity from all claims arising out of lawsuits, civil or otherwise. Mr. Speaker, I understand Cayman Airways, the reason we have given them the board of directors there a indemnity, deed of indemnity. I understand the liquor licensing board. And I could even understand the Turtle Farm Board because of the losses in finances that we're experiencing there. But I don't understand why we pick out these at this time. And the advent of a new legal services law, which means we do not need them anymore, because this new creature of counsel will now be responsible, unless, of course, we are going to appoint them once more. Mr. Speaker, I cannot understand why the government would be given a deed of indemnity unless they're suspicious of something having happened. Maybe. But if we, at least, at the very least, we expect something. In the Cayman Airways instance, we know that it's insolvent. What is the cause for this? Is it because the lawsuits by other lawyers have been filed? But if I can't assume that they're going to be successful, Mr. Speaker, why are we giving them indemnity then? Are they assuming that they're going to fail? Or they're going to be successful? I don't know. That could be a cause of this. Mr. Speaker, I know one. This total protection for everything that we have done here, I can't support. The government is going to have to do this one on their own. Mr. Speaker, I am seriously concerned about why an indemnity is being issued to these lawyers of CARA that was created for the purposes of AML and CFT. And the accountants who are found in the same, themselves in the same shoe, nothing has been issued for them. Or will that come after the fact too? Mr. Speaker, the Attorney General needs to explain this as to the reasons why this is being done at this time. Like I said, I understand Cayman Airways because of their insolvency and the likes, but if these are insolvent, then let's hear that's the reason why.
Does any other member wish to speak? Does any other member wish to speak? Call now on the Attorney General to.
Thank you, Mr. Speaker, and I thank the honourable member for his contribution to the to the debate. Mr. Speaker, I think I explained in my presentation that because of the weaknesses that was identified, or were identified rather, in the anti-money laundering mutual evaluation report done by CFATF, that it creates a difficulty for the jurisdiction, Mr. Speaker, a reputational difficulty. And the attorneys were designated by Cabinet as a self-regulatory body to effectively perform a function on behalf of the state, Mr. Speaker, the government, the So they, in effect, were carrying out a public function. Had it not been for them, the government would have to find the resources to establish a public body, maybe a compliance commission or something, staff it with public officers, pay them to do all of that, salary, health care benefit, everything. And they would have been then indemnified and provided with immunity, Mr. Speaker. So it was considered quite sensible, Mr. Speaker, to have this self-regulatory body in the same way we have the accountants perform this function. Mr. Speaker, I don't know that there is a particular time frame within which to bring a deed of indemnity or to provide a deed of indemnity. Mr. Speaker, Mr. Speaker, it only becomes necessary or relevant, if I might say, if, Mr. Speaker, there is a suit brought against these persons and the claim is successful and they are required to pay damages and or cost out of their own pocket. Mr. Speaker, that would have been done for the same public servant enjoy the same sort of protection. And so I am not so sure why the timing has to do with it, Mr. Speaker, and so on. And Mr. Speaker, so there is really no, if I might call it, perfect time as such. It is what it is. It is an indemnity, and it applies to members who are there now and members who may have resigned, Mr. Speaker. These things, some of them manifest themselves later on in life and so. So, Mr. Speaker, we don't know. We don't know. But the government has an obligation to do this for them. So, Mr. Speaker, I can't speak to the number of lawsuits that are before the court. That is a matter for the court, Mr. Speaker. We don't know what the outcome of those are going to be, and I say no more about that. Sufficient unto the day, if and when those are dealt with, Mr. Speaker. And so, but I am not so sure what is the suspicion. The only concern, Mr. Speaker, for those who are involved in those lawsuits would be that if they are successful, then their costs and their whatever it is be paid. That's all they would be.
Mr. Speaker.
That's all their concerns would be, Mr. Speaker. So it is not, in my view, an issue about why it is being brought and whether it
Mr.
is
Speaker.
related to a particular lawsuit and so on. So, Mr. Speaker, I do thank you and I thank honorable members for their contribution.
Honorable, the AG has sat down. I think he has completed his. You are rising on a point of order.
Yeah, Mr. Speaker, I rise on a point of order before you finish speaking, but it seems strategic here. But I was just point of elucidation and clarity of whether this bill is retroactive or not, because I couldn't. That's why I wanted to ask the question before he sat down. But I see that he intentionally tried to sit down before he is forced to answer this question.
I think you might be stretching your imagination a bit, but honorable member, all members had an opportunity to speak. I called members twice, and the only one to rise were the honorable leader of the opposition. I gather you must have wanted to speak. Yeah, but you were outside the room. That's why you need to stay in your seat. And members need to sit here more often and stop complaining about quorums when you should be here. I need to go that far because I've been given a very rough time in that chair tonight when there was no reason to do so. And I might not have longer be here, I don't know. But I can tell you this, I'm not going to put up with it much longer. The question is, be it now therefore resolved that the Legislative Assembly hereby authorizes the issuance to members of SILPA's board and CARA of a deed of indemnity guarding against the potential liability of members of the SILPA's board and CARA. All in favor, please say aye. Aye. Those against?
No.
Division, please, Mr.
The
Speaker.
ayes have it.
The Speaker, division, please.
Clerk, divide.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell.
Aye.
Honorable Juliana O'Connor Connolly. Honorable Dwayne Seymour.
Aye.
Honorable Roy McTaggart.
Aye.
Honorable Joseph Hugh. Honorable Tara Rivers. Captain Eugene Ebanks.
Aye.
Honorable Barbara Connolly.
Aye.
Mr. David White.
Aye.
Mr. Austin Harris. Honorable Art McLean.
No.
Mr. Alvis Aku. Mr. Kenneth Bryan.
No.
Mr. Anthony Eden. Mr. Christopher Saunders.
No.
Mr. Ezra Miller. Mr. Barnett Bush.
The results of the division: 9 ayes, 4 noes, 5 absentees. The motion is carried. Honorable members, we have come to the end of a long enough meeting, and we are about to celebrate, and I hope we can do that, Christmas with our families. And so I want to wish you and your families a blessed Christmas. All good things will be yours, that you will be safe, and that you will be able to spend quality time with your children, your family. And I do want to wish the same for all our people from West Bay to Spot Bay, and trust that it will be blessed throughout this Christmas season. Very special greetings to my constituency of West Bay West. No doubt all of us realize that this year, not just passed by, we're going up to the end of it, has been a rough year. And we ought to be thankful that we are still here, that we were able to accomplish so much for our people. that no guns rolled in the streets, that we were blessed that we could move and congregate where we needed to at times, even though with restrictions. And so I look back on this year and we say it's been a rough year. But I look forward to the new year. And the Christmas carol says, "Yonder breaks a new and glorious morn." That speaks of hope. And that's what we must have, hope. Trust in God and hope. Have a good Christmas, all of you. Honorable Premier.
Thank you, Mr. Speaker, for, I believe, speaking on all our behalf in terms of wishing everyone a happy and blessed Christmas. And with that, Mr. Speaker, I move the adjournment of this Honorable House, Sine Die.
Be careful in all your nocturnal activities. Question is that this Honorable House do now adjourn. Sine Die. All in favor? Those against? The ayes have it.